Hopefully this works. Okay, that looks better. Sorry about that. I've been writing all day long, and I didn't realize that it was 3 o'clock or 6 o'clock if you're on the East Coast. So sorry about that. I was getting carried away, just accusing Adrian Love of doing evil things that she definitely did. Um, I get excited like that. What did I say we're going to start with? I think I said we were going to start with, was it Steele or the name thing? I said we're going to look, ooh, the inmate's name. That's a stupid one. I think you guys are going to like this one. I think that's Graham. No, that's not right. It is Baker? No. Is it Graham? Bup, 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 bup. Sorry about this, everybody. Adamia Graham. Morgan Baker. Is it Baker? Let me see here. No, this is the Don Samuels case. We are going to look at this later because it's delightful. Lewis? What's Lewis? Nope. Hmm. Wilson, O'Neill, Fagan, Graham. Then I think this is the Brian Steele case. Actually, maybe we could start with this one. This is a case that I haven't looked at all yet. But Brian Steele did oral argument in this case like 3 weeks ago. Okay, everybody, gonna open up my. I'm sorry to the 12 of you that are watching. To me, just being super unorganized. There we go. Getting a little bit together. Cat is working. Can you guys? You guys should be able to hear me now. Okay. Aaron, other Aaron. Okay. I really wanted to show you this one case. I think it started with a B. Basically, it involved a case where this one guy has been trying to. Is it Barber? Hmm. So there was this case where there's this one guy in Georgia who's been trying to get the state to recognize his name, his real name, for several years. They keep calling him by the wrong name, and he's not even contesting his conviction or anything. He's just trying to get the state to call him by his real name. I think he's doing a life sentence. And he's saying in his motions, yeah, I'm guilty. I did this. I just want to be called by my real name. And it's been through multiple rounds of appeals, all because of the name thing. I downloaded the whole thing just to be ready for it, and now I can't find it. That's frustrating. I know, right? Graham Baker Damiac. I don't remember this case at all. Ooh, this is a case we're going to look at for. Actually, let's start with this one. So this is a case that is set for hearing for, I believe, Tuesday, the 16th. Make sure this. Okay, yeah, this is the right one. So this is it. The issue revolves around a speedy trial motion. This is Georgia, not a Fulton County case. It is a Houston County case, I believe. Yes. So this is being heard on Tuesday. And let me just set the I don't know, preface this case a little bit. So he's already been tried twice. The first time was a straight hung jury. I believe it's 7 or 8 charges. It's a murder case. The second time he was acquitted on 5 out of the 8 counts. And there was a hung jury on the last 3. And he's currently awaiting his third trial. I believe that'll just be on the 3 remaining counts, because double jeopardy on the other 5. So, yes, he's now awaiting his third trial, and he's trying to get a speedy trial, and the state is pushing back. They're saying that he waived his right to a speedy trial. So let's just get into this. And then after, maybe we can watch the little Brian Steele argument. So appellant Jenkins appeals trial court's order dismissing his demand for speedy trial. Jenkins was indicted for murder, and that's jurisdiction. The Supreme Court of Georgia has original appellate jurisdiction in murder cases in Georgia. If it's not a murder case, this would have gone to the Court of Appeals first. So, same thing, jurisdiction. He was indicted for malice murder, felony murder. I believe he was acquitted on malice murder, but not felony murder. Let's see, Jenkins timely and properly filed a statutory demand for speedy trial on January 11th, 2024, and then amended that demand on March 11th, 2024. Oh, this is Lawrence County, not Houston County. I got my counties mixed up. This is, this was the Lawrence from, it's Hamilton's boy. What's his name? I can't think of it. That Lawrence, though. The trial court ultimately denied Mr. Jenkins' March 11th, 2024 amended demand for speed trial on January 13th, 25. Jenkins timely appealed the denial of that order January 24th, 25. Mr. Jenkins' first statutory demand for speedy trial was made on January 11th, 2024. On March 7th, 2024, the trial court dismissed the demand because the defendant has failed to serve the judge. Which is one of those, this whole service thing in the law, we kind of need to figure out a better way to do it. It's kind of an outdated thing. Obviously, like, people should be aware of filings, but like, we have the internet now. Like, just putting something into the docket should be enough. It's kind of like receipts when you go to the store. We don't really need to do it the same way, especially not the CVS way, but nonetheless, we still get these little pieces of paper every time we do a transaction. Unless you just steal. The court's whimsical dismissal occurred without a hearing or due process, and Mr. Jenkins' trial counsel later averred as an officer of the court that she personally served the demand for speedy trial upon the assigned judge, and that she additionally provided verbal notice of its filing at the time of arraignment and every court date thereafter. So yeah, it seems like she probably did serve the judge, but something happened. On March 8th, the case appeared for calendar call, and the state requested a continuance. Jenkins objected. On March 11th, Jenkins filed an amended demand for speedy trial. Later that same day, the trial court filed an order granting the state's request for a continuance. Over 5 months later, Mr. Jenkins finally went to trial, but on August 20th, 2024, the trial court declared a mistrial because of a hopelessly deadlocked jury. On September 30th, 2024, we might need to go through all these dates on like a calendar or something because they're hard to track, but on September 30th, Mr. Jenkins' trial counsel submitted a notice of leave of absence. It was the county courthouse. Yeah. I'm not sure how big this county is. There's so many counties. I think it's one of the medium-sized ones. Let's see, about 50,000 people. That probably puts it in the top third of county sizes. So on September 30, 2024, Jenkins' trial counsel submitted a notice of leave of absence, and it was file stamped on October 7th. The leave included notice for December 18th through January 6th. So basically the winter holiday season. So it's like 2 weeks, basically Christmas and New Year's. So a relatively unimpactful leave of absence, I would say, was served upon all judges, clerks, and opposing counsel, and included Mr. Jenkins' case. No objection to this requested leave in the record, and the trial court noted that no objections to the leave were filed, and the court did not deny it. This will matter later because the state's going to say that because the person requested vacation, that prevented them from doing the speedy trial or satisfying the speedy trial demand. Also, on October 7th, the trial court filed an order for continuance due to Hurricane Helene and held that the statutory demand for speedy trial was thereby tolled. Not canceled, just paused, basically. The next day, the trial court specially set the case to begin trial on October 22nd, 2024. So I guess that would be just 2 weeks later. On the first day of trial, Mr. Jenkins' trial counsel filed a motion to dismiss, asserting in part that service of the January 11th, 2024 demand for speedy trial was proper because she personally served upon the judge to whom the case is assigned a copy, which was the only reason the trial court denied it. So if it had been properly served, the court would have granted the motion to dismiss, apparently. The trial court denied Mr. Jenkins' motion to dismiss on October 23rd. I guess it'd be the next day. And the trial proceeded. Trial jury found Jenkins not guilty of malice murder and not guilty of 4 counts of ag assault. So what remains? Jury's hung on felony murder and 2 ag assault counts. The trial court declared a mistrial for 2, 3, and 8. So I guess he's still facing murder. On October 30th, 2024, the trial court scheduled the case for a calendar call to occur November 22nd, 2024. They have a month-long St. Patrick's celebration in this county? Okay. Now, I mean, it's kind of weird to be named after a French guy and have a month-long St. Patrick's celebration. But nonetheless, it is a month-long St. Patrick's celebration. See, now I'm just thinking about like having a drink, but okay. On October 30th, so I think that's just like 2 days later. That's crazy. He's going like back to back to back on these cases. On October 30th, the trial court scheduled the case for a calendar call to occur November 22nd and scheduled the trial for the week of December 16th, 2024, during Mr. Jenkins' counsel's granted leave of absence. So it's not as if, the leave of absence was filed after the trial was set to start. That makes sense. Other criminal cases in Lawrence County included during the November 22nd, 24 calendar call were set for trial during the week of December 2nd, when Mr. Jenkins' counsel did not have leave of absence. So there is a specific window of time during that term of court when they could have had the trial and it wouldn't have conflicted with the vacation. And again, it was December 18th to like January 6th, so it was pretty much during the holiday season anyway. See if I can make this a little bigger. Here we go. Okay. Jenkins' counsel appeared on November 22nd for the scheduled call and brought to the attention of the trial court that trial counsel had properly filed a leave of absence on October 7th. As a result of that assertion, the trial court entered a rule nisi for a show cause hearing on January 8th, 2025. Will Nisai conflated trial counsel's assertion of her properly filed and granted leave as a request for continuance at the request of defendant, and held that this request would force Mr. Jenkins' trial to occur after the statutory demand for speedy trial has run. So it seems like the court is saying, because you are trying to have your vacation during the time you said you're going to have your vacation, you're requesting a continuance, even though there was a specific period of time when the trial court could have held the trial. Trial court also filed a continuance order on November 25th. This order again conflates Mr. Jenkins' trial counsel's granted leave of absence as a request for a continuance, and at the request of the defendant, the case would be continued. That's not what happened. It was two separate things. Continuance and a leave of absence are different things. The trial court then entered a Rule 9 specially setting the trial for the week of January 27th, 25. Mr. Jenkins filed his next motion to dismiss on December 4th, 24, and the trial court scheduled a hearing on the second issue to dismiss on January 8th. The sole issue was whether Mr. Jenkins' statutory demand for a speedy trial should be dismissed as waived because his trial counsel filed a leave of absence. The trial court determined that because trial counsel went forward with her leave, again, it wasn't really what happened, she just had a leave of absence, so it was waived. Second motion to dismiss explains that the first one served on the judge was properly served. However, the trial court had improperly dismissed that one. Hey, Bahira. Next, the motion says that although the Chief Justice's tolling order required the parties or interested persons seeking to avail themselves shall certify in the relevant judicial proceeding that the effects of Helene have prevented the action of which the relief is sought. The trial court unilaterally imposed an order tolling these deadlines without adequately enumerating conditions precedent for the order to be effective. The trial court noted in this order that on October 30th, 24, it specially set the case for trial the week of December 16th. The trial court also noted that it dismissed Mr. Jenkins' first statutory speedy trial demand due to the demand and accompanying certificate of service not stating that the presiding judge had been served. Thereafter, the trial court addressed the proper deadline for Mr. Jenkins' trial according to his ruling on the same. The trial court held Mr. Jenkins' trial must begin by February 3rd, 25 in order to avoid a discharge and acquittal. The trial court reserved the issue of whether trial counsel's valid leave of absence waived Mr. Jenkins' demand for a speedy trial until after a show cause hearing, which was set for January 8th. The trial court entered an order dismissing the statutory demand for speedy trial on January 13th, 25. The trial court had scheduled the case for jury selection the week of December 16th, 2024. And in the order alleged that this was the first time a trial week was available after the second mistrial, so this would be the third trial. However, the presiding judge had a jury calendar the week of December 2nd, 2024. So there's a specific time when the trial could have been held during the speedy trial period that wouldn't have been in conflict with the vacation request. If you as a lawyer get named in some embarrassing order, would changing your name be a good move? You know, I haven't thought about that. I guess it could. I'm sure, like, man, I don't know. Because you probably have to, like, give notice to everybody that your name's changed. But I guess if it was, like, a future thing, you wouldn't, like, necessarily know who you have to tell that your name has changed. So maybe you could get away with it that way. It's an interesting question. I'd probably just change careers at that point. We can ask Tyrone Blackburn in a couple months. They don't put bar numbers in the order's opinions. A lot of times they do. I mean, it depends on the order. I guess it would depend on what kind of embarrassing order it is. If it's like a misconduct thing, it'll have your name in it. But if it's just like you taking a big L for embarrassing reasons, then I guess maybe it wouldn't have your bar number in it. Next, the trial court averred that because Mr. Jenkins' trial counsel went forward with their leave, that was the next available date which it could begin Mr. Jenkins' third trial, February 4th. The AI lawyers Seriously, I have a case. I have an AI lawyer case up here somewhere. It's a Tennessee case. The problem with the AI lawyers is they never apologize. Like, you're clearly caught. You just, now I'm just getting, my other monitor just has pictures of Lawrence County just like cycling through. It looks kind of nice. Okay, sorry. Like, once you're caught, all you can do is just say, yeah, I messed up. I did a bad thing. Please forgive me. Don't take it out of my client. Just, I'll take all the punishment. And then maybe you have a chance of like getting off light. But these lawyers, every single time, they're like, I had no idea that AI could possibly hallucinate cases. I had no idea. Either that or they say, I had my paralegal write everything. And I thought they knew how to use like Westlaw. And a lot of times they'll say something like, I take all responsibility. And then half a sentence later, they blame the paralegal or they blame some contract lawyer that isn't them. It's every single time. I need, you know what? No, we're going to do this next. I need to get this off my chest. I didn't know I needed to get it off my chest until Creed said that, but we're going to do this. Underlings, yeah, absolutely, James. And judges know that too, you know? Like, remember when I showed the riddled with clip? I don't know if, not, I'm sure not all you guys watch everything, but it was an attorney said the car was riddled with bullets. And the judge says, was it riddled with bullets? And at that moment, you need to know that you've been caught. I don't know if it's the gig is up or the jig is up, because I've seen both lately, and now I'm not sure which it was. But, you know, once the judge asks you, was it riddled with bullets, you need to recognize that you're in danger. And they know the answer to the question they are asking you. It's not like they don't know whether it was riddled with bullets. They know that it wasn't riddled with bullets. All you can do is say, my bad, I was exaggerating. It was one bullet hole. What you don't do is say, it wasn't riddled with, but it contained bullet holes. Because the judge already knows there's only one bullet hole. She has like multiple monitors in front of her. And in the words of, you know, Judge, the cool one, what's his name? The one we like, the awesome one. The one that makes the faces. You know who I'm talking about. This guy. This guy. You're cooked, to quote him. Am I cooked? Yes, you are. Just take responsibility. Judge Farmer, that's right. Kevin Farmer. My hero. Just look at that. It's just beautiful. Now, is it as beautiful as this? I don't know. But they both make me very happy. Shut up, Matthew. Sometimes when I'm trying to do like multiple iterations, I just start adding letters to the end. That is what happened there. Man, I gotta find this Tennessee case. Or we could just look at this. That's funny. Okay, anyway, where were we? Jenkins. Okay, let's get through this and we'll look at some AI cases. I'll need to find them from that one guy on Twitter that does the funny cases. Yeah, true. It's usually like ASD, ASD. Okay, man, I'm way off. Man, I'm just distracted now. I just want to go into AI. What's that one California lawyer who posts them all? Rob. Rob Freund. All right, no, we can finish this one first. How many pages? It's like 5 more pages. Trial court analogized trial counsel's leave of absence and a motion for continuance. Trial court erred when it dismissed his statutory speedy demand. In Rice, the trial court relied on that case. Defense trial counsel asserted she was not ready for trial when the case was called, and she filed a motion for a continuance. See, that's a big difference, right? Filing a motion for continuance is a lot like filing a motion for a continuance. I hate naming things. It's really a miracle. I'm going to name my kids 1611 131 and 1611 133. So yeah, filing the motion for continuance is a really important part of the continuance. The trial court granted the motion for continuance and held that the requested continuance constituted a waiver of rights to speedy trial demand. You could do Chacapina's response to. I forgot about that. That's right. I saw you. Did you post that, or did somebody else post it and you shared it? I mean, I'm sure Tacopina was cooking. ASAP Taco. You guys know that SNL skit when Chris Farley would be like, he'd interview a celebrity and he'd just be like, hey, remember that time? And he'd just be super awkward. I feel like that would be what would happen if I were to interact with Tacopina. Remember that time you made Lewin really mad? Yeah, I think this case should be dismissed. This one here. I mean, there was a speedy trial demand. There was clearly time to hold the trial. The trial didn't happen. And not that it technically matters. It's not technically part of the analysis, but I mean, they have done 2 trials already, and they failed to convict him twice. So I mean, at some point, the guy's got to move on. Everyone needs to move on with their lives. Okay, and upholding the trial court's ruling in Rice, and upholding, this court, the Supreme Court, the right to a speedy trial requires strict compliance with the statutory requirements and may be waived by defendant's actions. Any request for Any request for a continuance following the filing of a speedy trial demand necessarily means the defendant will not be in court announcing ready for trial. So again, in Rice, there's a specific reference to a speedy trial. Or to filing continuance. That makes sense. If you demand a speedy trial and then you're like, I want to delay the trial, that's kind of a waiver, right? In Jones, this court examined the effect of an attorney's leave of absence on a speedy trial demand. In Jones, trial counsel filed a leave exceeding 30 days. Oh, nice. Oh man, I totally forgot this was a Fat Joe case. Oh my god, this is long. There's so many cases. Oh my goodness. Okay, we're definitely going to get to this at some point. We'll probably do this next. Is it? I assume it's good. Okay. This court held that the leave of absence was defective. Okay. So in James. Oh, I'm not going to say that. I don't want Taco to sue me. In Jones v. State, this court examined the effect of an attorney's leave of absence on a speedy trial demand. In Jones, trial counsel filed a leave exceeding 30 days, which I guess makes it a different kind of leave. The court held the leave of absence was defective. So there was no leave of absence granted because it was defective, and the failure to report for trial waived the demand. Okay, so neither of these cases are going to apply. The court has long held the position that a speedy trial demand cannot merely serve to effectuate acquittal by ambush. As awesome as acquittal by ambush sounds, I think we should celebrate that, and that a demand for speedy trial must be given significant weight and deference by the trial court. Dustin Jones only when a trial court made it virtually impossible for the trial court to schedule a trial was waiver established. That makes sense. I mean, if you file if you request to be gone for like 6 months straight, then obviously that's effectively a motion for continuance. Acquittal by ambush would be a great album name. Exactly. I completely agree. The more I think about it, the more of a funny concept that is. Like there's a bunch of defense lawyers hiding in the bushes, and a prosecutor's just walking by, and bam, acquittal. Under the circumstances of Jones, the actions of an attorney served as a waiver. That makes sense. It was such a long request for such a long leave that it's effectively a continuance. Those circumstances are not analogous, and his case is distinct. It's a different kind of leave of absence. It was only 2 weeks, and there was a specific period of time where they could have had the trial. Preliminary matter, his leave of absence was filed and granted. Importantly, the trial court held that because no objections to leave were filed, and the court did not deny it, the leave was proper and granted pursuant to. Because the leave was proper and granted, the question is whether the leave prevented the trial court from scheduling the trial during the October term. I should say the terms are 3 months long in Lawrence County. It's the fourth Monday of certain months. I had it open a second ago. But yeah, they're 3 months terms. So the October term would begin on, I believe, the fourth Monday. Yeah, the fourth Monday of October, and then it would go in 3-month increments. So that term would be October, November, December. And I guess on the fourth Monday of December, it would have become the December term of court. Wait, no. Yeah, that's right. Both Rice and Jones are inapplicable, and the trial court's reliance on them was misplaced. However, because this court reviews the denial of a statutory speedy trial demand de novo, no deference is owed. Trial courts. De novo just means, you start fresh. You don't look at the trial court's analysis. I think it means new. It means de new. A more applicable case is Burt's v. State. In Burt's, trial counsel filed a leave of absence. The trial court still placed the case for trial during that week. The trial court subsequently moved the trial to a different week, but the trial attorney had a previously scheduled leave during the first 2 days of that trial week too. Holding Burt's has strong parallels to this case. Utah attorneys. Hold on, I'll open that up actually. Ooh, it's a hearing. Oh, we're definitely watching this. Oh, man. That's going to be fun. Okay. Here we go. The state attempts to justify the trial court's denial of Burt's motion for discharge, but we need to elaborate very little. It is clear that while counsel was absent for 7 days by official leave during the 2 terms after the demand for trial, there were other weeks during May and in June and July when she could have been placed for trial. She was not. Let's say, despite the counsel's proper absence by leave, the state scheduled her case only twice in the 2 terms during those same 2 weeks. We do not see how the failure of this last-minute attempt at accommodation should be laid at appellant's feet in the total circumstance. This just seems perfectly reasonable. Supreme Court's just saying, hey, you got to make reasonable efforts to schedule the case for trial, and if you don't, you can't futz around at the last minute, try to schedule it, and then blame the defendant. If the defendant takes, a 2-month leave of absence in a 2.5-month term, then fine, that's something else. But you need to make a good faith effort and, a real effort to try to schedule the case. It seems like a common sense approach, really. In Fisher, the court examined the effect of conflict letter on a speedy demand. While the state argued that filing the conflict letter was a voluntary act that shows appellant consented to the waiver, the court did not agree with that assertion. Because trial counsel in Fisher voluntarily agreed to try another case, not even on the conflict notice, did this court find a voluntary waiver of the speedy demand. Should this court find that the leave of absence constitutes a waiver of a speedy trial demand, then the implications are troubling because no attorney representing a criminal defendant would ever be allowed to file a leave of absence pursuant to Superior Court Rule 16.1 without first getting the permission from their client, requirement that is not included in the rule. Yeah, basically there'd be no way to ever request a leave and move forward with a speedy demand. It would be either or. Alternatively, any filed leave would become meaningless. If you're a lawyer, that's true, and thus render the rule permitting criminal defense attorneys to not be at the beck and call of the court meaningless too. I took a vacation once in Big Law. It was 1 week, and at the end of that week, my boss was like, "You need to not take vacations. It's a bad idea to take vacations. You'll just fall too far behind. What you should do is only take off like a Wednesday night and then Thursday, Friday, and then you just can take the weekend, and that'll be your vacation for the rest of your life." And we were friends. I got along with that guy. I'm supposed to meet him for lunch on Monday. We're like friends. And he's like, "Don't ever take vacations again. It's going to be the end of your career." Oh my goodness. Here, the trial court had prior notice of the leave. The leave was proper, and there was another available calendar. Should the court find that the lower court here was right and that Mr. Jenkins' demand for speedy trial was properly dismissed, then exactly what the Birch Court feared comes to fruition. The statutory demand is gutted. Its rights provided therein are empty, and defendants attempting to exercise that right become dependent only upon the state and the court's convenience and ingenuity. I agree, Lee. This is not a case of. I was going to a wedding too. It wasn't even like I was just going to go, party in Cancun or something. This is, it was in the Philippines, so there was a fair amount of partying, but this is not a case of trial by ambush. It is not a game of gotcha, and it is certainly not an attempt to game the system. Mr. Jenkins has already gone to trial in this case twice, which is a good little, it's not legally relevant to the analysis, but if you're on the fence, the fact that he has stood trial twice, clearly he's not trying to get out of a standing trial. And, it wasn't, they weren't, convictions either. The state has failed to convict him 2 times. I went to the Philippines. Yeah. Yeah, some friends from Los Angeles, they're all Filipino, and they decided to get married in the Philippines. I think both the groom and the bride were American born, but like all the families were Filipino. They're disgusting UCLA grads, but nonetheless, I made it out there. Went to Cebu and Bohol. It was so nice. No guilty verdicts. Rather than let sleeping dogs lie, the state and trial court are taking every possible opportunity to prevent Mr. Jenkins from moving on from this horrible incident that is lingering and hanging over his head. Thus, for the aforementioned reasoning, this court should reverse the trial court's order dismissing Mr. Jenkins' demand for speedy trial. So this is set for argument on Tuesday. I don't know if we need to look at the state's response. It's basically just the opposing side of everything that we just looked at. I'm confused why I'm not being able to find my files, though. This is frustrating. My dad and stepmom got married there, but my dad can't go back there for some legal reason. Hey, you gotta do what you gotta do. Okay, so we're gonna take a look at this thing that Factual I just sent me. This is Utah. It's titled "Utah Attorneys Sanctioned After ChatGPT Fabricates Fake Case Law." I wish it fabricated real case law, because that would be even more concerning. So let me see. I'll read the description. Court of Appeals heard a case of AI being used to create a petition in a case that cited a court case that did not exist. That's about 20 minutes. We can take a look. Let me see here. Sorry, still getting used to all this stuff. YouTube? Not you. You? There we go. Okay, let's give this a try.
Good morning. We are back on the record in the case.
What's the sound like? Like me relative to the video? Are we relatively even? I write software. This stuff makes my brain break.
Gardner versus Cadence. I just wanted to note for the record the change of panel. I am Judge Michelle Christensen Forster, and I am joined on this panel by Judge Gregory Orm and Judge Amy Oliver.
Yeah, you gotta remember, I don't hear good. I don't hear well. So things are gonna have to be louder to me than it is to you, I'm sure.
We have called you all to this hearing to ask you a few questions about a petition that was filed by Mr. Durbano and Mr. Who signed it?
Bednar.
Mr. Bednar, who actually signed the petition. There was some information we received from the other side about that petition that contained some errors and some problems. Before we begin the actual hearing, could you please enter your appearances for the record?
Morning, Your Honor. Matthew Barnick appearing for the respondents to the order of show cause, Douglas Durbano and Richard Bednar.
Thank you.
Greg Salin and Cody Condes appearing on behalf of the respondents to the petition item.
This guy right here, he's ready for blood. He's just ready to pounce. Oh, you can't see my monitor. You can't see my thing. I need to be able to annotate with my mouse. Let's see. This guy. I don't know if you can see that, but it's that guy.
All saying we're respondents, but
yeah,
we're defendants in the underlying case.
Thank you. I think I will open it up to the panel to see if there are any introductory remarks that you would like to give.
First of all, how dare you?
Mr. Barnick, and then I will open it up to the panel for some questions.
Thank you. I'd be happy to. I'll give at least some introductory remarks, and then I can address whatever the court would like. As mentioned, I represent Mr. Durbano and Mr. Bednar on this order to show cause only.
You can just hear from his voice. He knows that he's cooked.
I do not represent Mr. Garner in the underlying case. This filing was a serious mistake. My clients apologized to the court, to opposing counsel and their clients, and certainly to their own client. They are embarrassed about this. They are disappointed in themselves and in the failure of their normal process that led to the filing of this petition. I don't know how much you want to hear from me up front, but I'd like to explain what we think happened here and what the firm has done to measures it's taken to make sure it doesn't happen again. And if I may, I'd like to add a little bit of background about Mr. Durbano and Mr. Bednar that leads up to the filing of the petition. Doug Durbano has practiced law in the state of Utah since 1984, and during that entire time has been a member in good standing of the Utah State Bar Association. Mr. Durbano had little, if any, involvement with this petition for interlocutory appeal. He's, of course, been involved in the underlying case. Doug was involved in a car accident on February 12th of this year, and for the next week or so was in the hospital recovering and out of the office, returned
No, don't do this.
To work on February 19th. This petition was filed on February 18th. It bears his name, but it does not bear his signature.
Okay, that actually makes a big difference. If his signature is not on it, he's not responsible for it. Usually just, I mean, in theory he is, but the person who signs is always the person who's responsible at the end of the day.
Richard Bednar.
It's actually a part of Rule 11, Rule 11 sanctions. If you ever hear those in federal cases, part of Rule 11 is that every filing has to be signed by an attorney in the, licensed or permitted to practice before the court. And that's specifically so that there's a person responsible.
Is the attorney responsible for...
Always say it wasn't you. Maybe not in Shaggy's circumstance. You could be a little nicer to your paramour. But, in court, yes.
Approving, signing, and filing the petition. Richard graduated from BYU Law School in
Thank God it's not USC.
1989. He then clerked for 2 years in Washington, D.C. at the U.S. Court of Appeals for Veterans Claims, and then remained a staff attorney with that court for about 15 years and ultimately returned to Utah in private practice. Because of his involvement in the court system, he has a deep understanding and commitment to the accuracy of court filings. He has never used AI to generate a brief or to generate case citations, with the exception of the LexisNexis AI tool. But his practice has always been to review and approve cases before they are cited in any filing with the court. That didn't happen here in this instance. What happened here was that Richard asked a law clerk in their office to prepare the initial draft of this petition.
No, that's not. You're going wrong already.
In their office to prepare the initial draft of this petition. Richard then did some work on it, and he and the law clerk exchanged drafts back and forth as those things go. And ultimately it was filed. He did ask that those case citations be checked, and later learned that didn't happen. But Richard did not do that himself. He does not point fingers at others. I'm simply trying to add context. He takes responsibility for this. He is the licensed lawyer who signed the petition.
What would be an appropriate offense that isn't just taking the L? Just take the L. There's nothing you can do. It's a very clear rule. That's why they have it. Apparently this guy didn't sign, not the lawyer. He's not involved in the underlying AI issue, but his client apparently didn't sign. But there's no defense. If you didn't sign, you can say you weren't that, it wasn't you. But whoever signed is 100% on the hook. There's nothing you can do.
And it was filed with the court.
So do I infer then?
Oh, so that is the guy that he was just discussing who signed. The first guy he was discussing who didn't sign, he's in less trouble. Because you can have multiple lawyers on a case, and not everybody's going to look at every document. That's totally fine and expected. But whoever signs, there's nothing you can do. It doesn't matter what happens. If you signed it and filed it, it's on you. Unless somebody stole your signature in your e-file credentials. Short of that, there's nothing.
That it was the law clerk who used ChatGPT to generate some portion of the filing?
Yes, that's correct. That's correct.
Is the law clerk licensed to practice law?
No.
That is the beginning, and that actually makes it worse. Because you let somebody who isn't licensed to practice law prepare a document for a client in a case. So that just really makes it worse. That doesn't help.
Yes, that's correct. That's correct.
Is the law clerk licensed to practice law?
No. No, and that's why I say Richard takes responsibility. He's the one who is licensed. They work together on the document, of course.
See, they do this all the time. I take responsibility, but also, it's the other guy's fault.
But ultimately, the lawyer who signs and files it is the one responsible. We all know that. And Richard's not trying to
He wants to have it both ways. He's giving excuses, but like at the same time saying, I take
hide
responsibility.
from that responsibility today. I'm happy to.
Was
sure.
Mr. Bednar aware that ChatGPT was being used to draft the petition?
No, he was not.
I believe that. I know that that's been a problem in a lot of law firms. I've actually talked to some. I'm not at a firm right now, but I talked to a partner at a firm in the South somewhere, Louisiana, Alabama, Arkansas, somewhere in that area. Not Mississippi, but she said that she hired. There were 2 first years or junior associates. And she gave them both half of a project to do, and it was like a big project. And apparently they both used AI, but they didn't like use AI together. So it was like 2 halves of a project that were like AI is arguing with each other because they didn't like, obviously generative AI with 2 different sets of information, you can get like 2 incongruent halves of a brief. And so, like, the night before the project was due, she was reading through this brief that the juniors had put together. And, like, it's just clearly AI. And, yeah, she asked them, and they both admitted that they were using AI. But the thing is like, they could have talked to each other. The least they could have done was use, like, one AI to do the whole thing. Because if you're just going to use AI, that takes, like, 3 seconds. So why didn't they just like get together and at least make a coherent AI, brief? But they didn't even do that, which is probably better for her because it made it easier to detect. But, I'd say that generally speaking, it's pretty easy to see AI cases just reading through because they don't, there's just something about them that won't look right. So it really is. I'm sure AI will get better, and it'll get better at, simulating actual briefs and actual law. But it doesn't really, there's just something off about it right now. And if you just read it, you can usually tell pretty quickly that it's AI. If you at least have like some background understanding of the what the law is. If you have no idea, like if there's AI in a family law case, I'd probably have no idea. But if you put it in like bankruptcy or some states criminal law, I'd be able to tell it's AI just by reading it. Just because stuff's just askew, askance.
And thank you for that question. I began by saying this was a serious mistake, and it was, but it was a mistake. It was not knowing. I don't believe it even satisfies the standard
It was absolutely knowing. You didn't check the citations and you signed it. That's knowing.
for recklessness.
It absolutely does.
He did not know that that AI had been used to generate anything in connection with the brief until after the fact, when they went back to try and reconstruct what had happened here, and then learned that yes, it had been.
And were there any conversations at any point prior to this brief being drafted about the use of AI in their practice and at their firm by this law clerk or
I'd be fine if there weren't. Like, you shouldn't have to say it, but I don't know.
any other employees?
To my knowledge, no. I don't think I've asked that specific question. But I've certainly asked that question about, going forward, and that AI was used. We acknowledge that in the generation, but I don't believe that Richard or Doug knew that in the drafting stage before it was filed.
And I'm asking more generally, did the firm have a policy, maybe something less formal than a policy for their employees about using AI or ChatGPT to generate work product?
Like, it's a good question, but at the same time, like, there is a policy. You have to, the person that signs the brief has to, read and check the cases. Like, that is the policy. Like, this would be a more specific policy, and I'm sure firms will have a policy like this going forward. But like, you definitely do have a policy.
I don't believe so. And I can stop to ask my clients specifically if you would like, but we've had a number of discussions and they haven't mentioned that to me, so I don't believe that was any kind of a policy. I can tell you there is a policy now.
I don't know, Aaron. Probably free.
And I think there is a place in the world for AI, but
Nah,
it certainly isn't
not yet anyway.
the place to write your brief for you and find your cases for you. We acknowledge that.
Well, I don't think it's the position of the court that AI isn't a tool that can be used by lawyers and whatever assistance it may provide. I think the concern we have is obvious.
I will say I've tried to use. I spent an entire evening trying to use like the paid ChatGPT to be useful, and I just couldn't get it to do yeah. I just couldn't get it to do anything like any kind of useful, even like summarizing of documents that I gave it. I think it's further away than people are realizing. Yeah, definitely. It can be useful. One thing that I like to use AI for, this is the only thing I've used it for. I mean, I've tried to use it for other stuff, but it just doesn't, I can't get it to be useful. Is if you have like writer's block and you can't think of how to say something, I'll write like a bad version of what I'm trying to say, and then I'll tell AI like, hey, make this good. And then it'll restate something. And usually it won't make it like the way I like it, but it'll make me think about a sentence or a paragraph structure in a different way. And then I can write it in my own voice in a way that I like. So I think that's one use for it. But in terms of research, it just doesn't it doesn't have a Westlaw account, so it can't access the law. So it's basically just going to be, using it's a large language model. It's just going to be referencing other cases and mimicking the style. I used to rephrase emails to be less sassy. Yeah, I actually have something similar. It's called Tiffany Adams. I send her briefs, and then she makes it less sassy and aggressive and openly hostile. Oh, man. Where would I be without Tiffany? I don't know. My goodness. I'd probably be in jail in Atlanta at this point.
That in this case, ChatGPT hallucinated at least one case and probably cited other cases for propositions that were unrelated to those cases in their holdings. And a lawyer didn't check that, right? We as attorneys, as you've said, when we sign documents for filing with the court, we're making a representation under the rules about the veracity of the information contained in whatever the document is that we're filing, and that's a responsibility we bear. So while AI is certainly a tool that people appear to be using successfully here,
yeah, writing an email and then not sending it is good therapy, even if you don't send it at all.
It obviously was unsuccessful, and there apparently wasn't an effort made to double check it. And that's really the concern, I think, for this court, is that there was a failing on the role of the attorney to make sure that what was being presented to the court was in fact accurate.
Well, and it implicates, in my mind at least, the duty of candor to the tribunal.
Yes.
Here is this case, and it supports our position, and the case doesn't exist. That moves it, in my mind, beyond a mere error. An error would be it's the wrong pin site. We didn't realize the case was later overruled by the Utah Supreme Court. There are, I was going to say 1,000, that's an exaggeration. There are a bunch of cases in Utah called State versus Carter.
Right, they laughed at something.
By the Utah Supreme Court. There are, I was going to say 1,000, that's an exaggeration. There are a bunch of cases in Utah called State versus Carter. Quite by accident, we cited the wrong State versus Carter. That's our error. It doesn't really support the proposition. But where you have a case that's non-existent and represent to the court by signature that this is valid authority, that's a more serious problem in my mind than a mere error.
Understood. I hear what you're saying, and I do think that the court.
I will say, thank God that this guy didn't decide to. This guy, not this guy. The effectively the defendant, not a defendant technically, but the lawyer who signed the document didn't choose to self-represent. It's definitely good to have a layer of separation between yourself and the I don't know what this is technically called, an appellate panel or panel of judges, whatever it is.
Needs to look at this as to what Mr. Bednar knew at the time the petition was filed. He did not know, and by imposition of duty, he should have known. We acknowledge that Royer versus Nelson is a non-existent case. It actually exists in Indiana as a table citation. There's no.
Hey, Karen, I meant to ask you, we can talk out like on Twitter later, but I meant to ask you about that gun case. I think you said oral argument was Friday, right? Or yesterday?
No content to it. It is a fake citation, but it was never intended to be that way. And that's the point I emphasize today, is what was in the mind of Mr. Bednar at that moment. I will say, harking to a part of Rule 3.3, they have filed a request for leave to file an amended petition, in part, of course, to protect their client from the effects of this initial petition, but in part to correct the misstatements in the original one. That's one of the requirements in Rule 3.3, and they have done that. Now, what the court does with that request is not within the scope of my representation, but I point that out.
Nor really within the scope of the hearing, but we're mindful of the.
Yes.
Let me ask this, is the client, Mr. Gardner, aware of the order to show cause and order and the hearing that was set today?
Yes, and I believe he's here. Mr.
Oh,
Gardner is
Mr.
here.
Gardner, all right, thank you.
That has been disclosed to him fully. It was not a pleasant phone call for them to make to their client, as you might imagine. But they have been completely upfront with them since learning of this, and have tried to be the same with the court through our presentation today. And I had a conversation with Mr. Salen last week to attempt to accomplish that same purpose. I'm prepared to go through each of these citations if you want to drill down to that level.
I don't think so. We can do that.
But I will say, certainly the Royer versus Nelson case does not exist. The West Side Nursery and the Granite something construction case, they are real Utah cases, but they don't stand for the propositions for which they are cited. The Jones-Waldo case, I think, is appropriately represented in the petition. State versus Wilden, State versus Spry are also appropriately represented. They probably aren't on point ultimately, but I think as far as what's stated in the petition about those opinions, I believe that's correct. And like I say, that's my summary. I'm happy to address that further if you'd like. And I will say that I mentioned something earlier, but the firm has adopted a formal policy now about how they will handle the writing and the submission of any filing with the court, but in particular those that cite case law. I'm happy to walk through that with you, just a 4-step process, but I want you to know that that is something that they have done. It's a small firm, but it is a formal policy now. They don't ever want this to happen again. Last thing I will say is, I guess 2 points, if I may.
While you're recapturing your thought, I was impressed,
I like that phrasing, recapturing your thought.
for what it's worth, that your clients promptly acknowledged that they should pay the other side its attorney's fees insofar as they were inconvenienced in having to respond to the bogus authority. I thought that was an appropriate
Thank you.
attitude. I'm not sure exactly how we go about, I don't know if an offer has been made or...
An offer has been made. I know Mr. Salen and his clients have considered that. The offer is still open, and I think Greg and I can easily communicate about that more if they're interested. But the offer is to pay all of the legal expense incurred in responding to the initial petition. I suppose more if that is deemed to be warranted.
What would be your position about a monetary sanction above and beyond making the other side's attorneys
How much should your client pay?
whole in view of the misrepresentation to the court? I know around the country, we did a little research, and where this has come up before, this is not the first time it's happened in the country. This is happening all the damn time. Sanctions of $1,000 here, $5,000 there have been imposed by courts around the country, I guess, to sort of
it needs to be significantly higher. It needs to be a minimum of like $15,000.
Make the point.
make the point, send the message more strongly than just making the other side whole would do. And I'd be interested in your position about the propriety of some such sanction in this case.
I think that's well within the scope of Rule 40 and what the court can do here. That's certainly not something.
Well, the client still has to pay for all of the the case expenses, right? And they'll probably have to pay the other side's expenses. In theory, of course, courts are going to try to make the lawyers pay, but in theory, the client would have to pay for some of the stuff. I assume in practice they don't, but
My clients would love to hear, but they understand that is a potential outcome of the hearing today. Rule 40 is it.
This lawyer's really good, by the way. He's doing a great job. I mean, there's nothing he can say to make this better, but yeah, I think he's doing a good job.
C or D, I've forgotten, that I think gives the court fairly broad discretion in imposing sanctions.
And obviously, neither that sanction nor the attorney's fees to be paid to the other side, those wouldn't fall to the client. The attorneys would be responsible for that personally. I assume there's no issue on that.
They would be responsible for the attorney fees for sure. They would not charge their client for that. The attorneys would pay those attorney's fees, and I assume the same would be true if the court imposed a monetary sanction as well. I don't think any of that can be passed on to a client, right? I guess I would. Sorry, Judge Oliver.
Yeah, I would just like to say, I think a concern I have in general, and this factors into at least my view of whether sanctions should be imposed and what amounts they should be, is that we had the benefit here of opposing counsel who pointed out to the court the use of.
Ooh, this is actually an interesting issue. So there have been several instances in which say the plaintiff's attorney files a complaint with a bunch of AI citations, and then the defense or the defendant counsel will file a reply but not notice that any of the citations are fake. And the court I think courts are increasingly upset with both sides rather than just the side that used the AI, because in responding to any kind of legal filing, you're supposed to, check the case law. And I don't know if that's what they're going to get into here, but it came up, I think, a Tennessee case recently. There were some sassy footnotes from the judges.
Citations that were hallucinations and didn't exist, and case citations that were incorrect as a proposition of law. We as a court system, as everyone knows, we're very busy. We have more work probably than we can do as quickly as we would prefer. And so it can't be that the judiciary is the backstop to double check and triple check every citation that's made in a filing that's presented to the court. We simply don't have the resources or the time to do that. And so what we do is we depend very much on the honor system of those attorneys who practice before us. And that is part of our rules, Rule 3.3, Rule 40, that when a document is presented to the court with a signature of a licensed attorney, that we can trust that what's being argued in there is being argued in good faith and based on real cases.
Yeah, it would be nice. We do need more judges across the board in pretty much every jurisdiction.
And case law, and is a valid and good argument for the extension of the law. And I think if this problem were to become more widespread, it's a larger problem for the judiciary and the integrity of the judicial system. And so I just want to say for the record that this is something that we have grave concern about, and something that we need to make sure that attorneys have grave concern about, and that they make every effort to make sure that what they present to this court under their signature is accurate to the best of their abilities. We certainly understand that errors may occur, typographical errors, miscites and things of the nature that Judge Orm discussed. This is an entirely different category. And so that is why we called this hearing, which is quite unusual for the Court of Appeals to do. And so I say that just to explain why really we're here today. We take this matter very seriously on behalf of not only our court, but the entire Utah judiciary. And it's something that is very serious.
Absolutely. Thank you. And I confirm that my clients are committed to upholding the honor system that the court has just articulated. And they have learned that lesson in a very difficult way. And as I said, they come here embarrassed and disappointed and perhaps more firmly committed to make sure this never happens again than someone who hasn't been involved in this kind of a failure.
Well, and certainly we appreciate and recognize, we've all been around for a while, and we don't necessarily understand the nature of this new technology as well as we all should, right? But Judge Oliver is correct that it can't be the courts that that harness and utilize this technology as a check on anybody, right? We have to count on the attorneys to utilize it correctly.
Absolutely.
If they are going to be.
Yeah.
Well, I was thinking, how in the heck would these guys, people of my own approximate vintage, how in the heck did they know how to use
My approximate vintage.
AI?
Yeah, I don't.
And your explanation, of course, they don't. But they have a law clerk who does.
I bet you do now, though.
Really more of a failure to supervise situation, lack of candor to the tribunal, rather than, wow, my contemporaries are on top of this AI thing. I'm impressed. This was a explanation, I have to tell you, I kind of anticipated. That it was an underling of some sort that kind of went nuts with ChatGPT and let AI write the brief that the law clerk should have been drafting, or the petition that the law clerk should have been drafting. But yeah, the whole thing kind of makes me really
Feel old.
nervous and queasy, and the less I know, I shouldn't say the less I know about it, the better. I obviously need to
Undertake the counsel
understand
of.
it. Some few months ago, judges were all asked to take a poll about AI and their use of AI and so on, and then there was an open-ended question at the end, and I completed that question by saying, as far as I'm concerned, there's so much real intelligence in the judicial branch, we don't need the artificial intelligence.
Yeah, I understand that. I think the last thing I was going to say was just to point to some case law. Rule 3.3 talks about knowing and reckless, and there's some history with that. It didn't always say reckless, but I haven't found any citations to mens rea standards in the context of the rules of professional conduct, so I look to the broader Utah law for that. This is well defined in many cases. Negligence is a failure to exercise the degree of care which a reasonable person would have exercised under the same circumstances, whether by acting or by failing to act. And I believe if the court is looking for a mens rea standard to latch onto, that's the one that I think fits here. Utah law, interestingly, defines recklessness within the context of gross negligence, that recklessness is subsumed by the court's definition of gross negligence, and that is the failure to observe even slight care. It is carelessness or recklessness to a degree that shows utter indifference to the consequences that may result. I don't believe the facts here can satisfy that standard. That is for the court to determine, of course. But if you ask me, does it satisfy the negligence standard, I would have to say I think it probably does. But I'll leave it at that unless your honors have any further questions from me.
I was smiling not to be uncorrect or whatever, but Judge Orm and I just sat on the oral arguments that we had just before this. That same exact phrase and standard was discussed. So
I heard that.
We may have a little familiarity with utter indifference.
Right.
Yeah.
Okay, thank you very much.
Thank you. Did you have anything, Mr. Salem, that you would like to respond to?
No, Your Honor, thank you.
Okay. Well, thank you both for being here today and for, we do very much appreciate your acknowledgement and the respect that you are handling this. We appreciate it. The judicial system appreciates it as well. We will take this matter under advisement and render a decision at a later time.
Thank you.
Yeah, I mean, the guy that's appearing there is the one who did the wrong thing, so that kind of. Hey, I'm trying to do a thing here. I pulled up a couple of. Oh God, no!
He seems more
No.
concerned with the
Oh,
tactics
God.
that police
Oh,
use
God.
than really giving them good explanations. Now,
Oh,
Brooks,
boy.
like I said, represented himself
No.
throughout the course of this trial.
No.
And to give you a sense, this is where he went when he cross-examined the
Oh,
state's
God.
witnesses. You can kind of see his defense.
No.
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times
Wow, that was actually, he kind of just cooked this guy. There we go.
people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get
Brooks is
past
kind of
you.
cooking here.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
There we go, Brooks.
I assume that he was.
You thought because of that sound that there had to be some mechanical problems going on with the engine.
Man, he sounds, usually he's just being crazy. Now he's cooking. I like it. You love to see it. So I pulled up a couple of AI opinions. While this, didn't he win like a new appeal or something, and then he decided to like step back into his case or something like that? I know nothing about this guy other than that he looks angry in YouTube thumbnails quite often. Oh, right. I was like, what case are we going to look at? I forgot that Kat sent me that, this case here. There we go. I didn't know. No. I did not watch that case. Maybe I should have. I didn't really watch any criminal stuff until YSL, because I thought Brian Steele getting locked up looked funny. And then that like changed my whole, my whole life, apparently. So this is the Fat Joe, aka, Joe Cartagena, aka Fat Joe, versus I think Terrence Dixon's local counsel, Tyrone Blackburn, and T.A. Blackburn Law, PLLC. And I can't do any more Massachusetts cases. I can't cover a Massachusetts case without some psychotic person yelling at me with some kind of meme I don't understand. It's just, I can't do it anymore. But yeah, it seems like I saw the headline about the breathalyzer. It seemed ridiculous, pretty ridiculous. The other thing with I aside from YSL, I generally try to do cases that are like a little bit less covered. That one's getting a ton of attention. I don't know if I'd really have anything to add to that case. It's kind of the same way with Karen Reed, actually. Like there was no shortage of opinions on the Karen Reed case, so there kind of wasn't anywhere to go with it in terms of like covering the case. You know, I did like a little bit of stuff, but it's just there wasn't really anywhere to go with it. But it's definitely a crazy case. There's no denying that. Okay, what do we have now? As many typos. I mean, I'm always down to point out typos. That's not the issue. So this is the Fat Joe. Apparently there's some AI stuff here. John Adams under. I think we're gonna mostly skip to the argument because that's what I'm most interested in seeing. You recognize any of these cases? Ashcroft versus Iqbal. This is going to be about a motion to dismiss. So it plays Twombly in here too, I'd imagine. No, Twombly. Okay. There's a case from Georgia a few years ago that saw Ashley Merchant defend. Yeah, interesting. If you remember, let me know. I can look it up. Check out the preliminary statement. Dixon and his lawyers. I don't even remember Terrence Dixon. Is that the plaintiff? Terrence Dixon and his lawyers, Blackburn and the firm. Your motion to dismiss the Second Amendment complaint should be denied for many reasons. Yeah, definitely. It's one or the other. Chief among them is that defendants rely heavily on evidence outside of the four corners of the complaint, including from a 36-paragraph declaration that the court should ignore, and have cited cases that simply don't exist and have miscited cases for propositions for which they simply do not stand. There are at least 10 instances in the motion where defendants cite cases for inapposite propositions or quotes language found nowhere in the case, commonly referred to as hallucinated case citations, which in all likelihood which in all likelihood were the result of Blackburn's irresponsible reliance on AI-generated content without manual verification. I don't know if I like awful lawyers or great lawyers better. Probably awful, to be honest with you. Ryan Duke. I don't remember that name. Oh, right. The Duke case. So Ashley Merchant has a monopoly on defendants named Duke. She represents Duke YSL Duke, of course. And then the defendants in that case were Brian Duke and Bo Dukes, I believe. So there was Duke as a nickname, there was Duke as a last name, and then there was Dukes as a last name. So there's something about Duke that, Ashley Merchant just has on lock in the state of Georgia. Civil cases, criminal cases, doesn't matter. Almost died. Oh, man. As shocking as this is coming from Blackburn, is it? Oh, there we go. Sorry, that was just the introductory of the house. It is not surprising to one familiar with his history. He's going in, like, right off the bat. Federal judges have admonished Blackburn within the past year because his filings were replete with inaccurate statements of law and wholly fabricated quotations from case law. Damn, well, if you're going to bring judges' quotes into it, Joe, I guess finally, you might win something. Jerk. Going to bring facts into the case. Blackburn recently blamed these errors on his misinterpretation of new legal technology. He's being so shady. We're like 2 paragraphs in. It's the 2nd paragraph. And he's... I love Joe. And it represented just days after... Oh, that reminds me. I need to do the Lewin case. It's my list of topics I need to get through. The Ninth Circuit case, the reversal. That was a really interesting case. It was interesting how shitty it was for John Lewin to move forward with that. It was really like offensively, affirmatively and intentionally misleading what he did. And also, I hope he never gets donuts ever again. Or like, I hope some of you get that reference. It represented just days after filing his motion that he had taken the appropriate steps to ensure that he would, quote, never make the same errors again. The motion is, unfortunately, just the latest example of Blackburn being a complete and utter serial disregard of his ethical obligations. In addition to disregarding Blackburn's fictional authorities, the court should impose harsh sanction for this repeat conduct. Blackburn's egregious misconduct in drafting the motion overshadows defendants' substantive arguments, all of which fail against the well-pled allegations of complaint describing defendants' calculated campaign of defamation, extortion, and malicious harassment designed to destroy world-renowned musician Joseph Fat Joe Cartagena's reputation and business. Who can forget Fat Joe's lyrical genius, like when he says, lean back, lean back, lean back, lean back. Dixon fabricated and publicly spread knowingly false, scandalous accusations against Cartagena. Is it Cartagena? Am I saying that right? With the intent to coerce Cartagena into paying millions of dollars he did not owe, including that Cartagena engaged in familiar relationships with underage girls and assaulted a woman in Wisconsin. When these tactics failed, Dixon enlisted Blackburn, who first sought compensation for Dixon's alleged unpaid wages. But quickly, there will be no Rihanna slander in this. But quickly threatened disseminating false allegations for statutory rape, forced labor, trafficking, and a RICO lawsuit if he did not pay $20 million. After Cartagena refused to back down, Blackburn published further defamatory statements, including the knowingly false statements that Cartagena ordered a hit job against Dixon, that he had a recording of Cartagena's alleged former 16-year-old girlfriend. Of course, defendants knew that these statements were false when they made them to coerce a payout. We all have, Aaron. There's nothing wrong with that. Defendants' unconscionable conduct forced Cartagena to commence this lawsuit to protect his reputation, career, and emotional well-being. Plaintiff asserts 3 causes of action: defamation against Dixon and Blackburn, and IIED against both defendants and the law firm, all defendants. The motion seeks to dismiss the complaint in its entirety is a tactical misfire. Most of defendants' arguments amount to disputing the veracity of Cartagena's allegations, which the court must accept as true on a motion to dismiss. Defendants also improperly rely on either evidence outside of the pleadings or fake quotes from cases. Rule 12 is dismissal generally, I think. 12b1 is the court doesn't have subject matter jurisdiction. Subject matter jurisdiction. 12b2 is the court doesn't have personal jurisdiction. 3 through 5, I have no idea. 12b6 is failure to state a claim on which relief can be granted. I think there are like 8 or 9, actually. I haven't looked at this since law school, so it's been a few years. Let's see here. Oh my god, this is the worst. Rule 12. There we go. 12B. 3 is venue, 4 is process, 5 is all different kind of process, 7 is failure to join a party. Okay. Anyway. Defendants also improperly rely on, that's funny, what is left over are half-baked arguments that are completely divorced from the complaint's allegations and genuine legal precedent. In reality, the complaint more than adequately pleads every necessary element of Cartagena's defamation and IIED claims. Come on, I want to get to the part where he gets really offensive with it. Statement of facts. We don't need to go through this. It's basically just more detail about the things that I just read. I want to get to the shadiness. Ashcroft, Twombly, and versus, was it Bell, I think, and Ashcroft v. Iqbal are the two most well-known motion to dismiss cases. They're the modern standard. Sassy Saturdays with me. Absolutely. I kind of want to start like drinking later and see like, you know, how silly I can get before I like start offending people. Defendant's motion is convoluted and disjointed, riddled with irrelevant asides, cursory single sentence arguments in the preliminary statement without expansion in the rest of the brief, in arguments about prima facie tort, a claim that Cartagena does not bring. Despite its lack of coherence, sorry, it's just too good. I'm sorry. Oh, boy. Okay. Despite its lack of coherence, defendants appear to advance several arguments in support of dismissal, including claims of litigation privilege, assertions that the challenge statements are protected opinion or truth, and repeated contentions that the complaint fails to plead actual malice. The court should disregard much, if not all, of the defendant's motion, which relies on hallucinated cases and evidence outside the four corners of the complaint. In any event, defendants' arguments are baseless. So motions to dismiss are decided just on the what's inside the complaint. If it goes outside of the complaint, it becomes a motion for summary judgment, if anything at all, which is Rule 56, not Rule 12. I don't know why I said that. There's no reason anyone needs to know that. Okay. You know, I didn't realize that Florida was Florida, just with a space, for like years. I don't know why I shared that information, but I feel like I need to be honest with my audience. I just straight up didn't notice that for a really long time. I was really embarrassed when I realized it was just Florida with a space. Yeah. Anyway, defendant's motion is not only unreliable, it is a shameless abuse of the judicial process that the court should flatly reject. First, the court may not. This is, you know, like when Doug did his did the wow, what a mouthful motion. He commented on Twitter after the fact that he had a lot of fun because you rarely get to write like that. This is one of those cases. Like, I'm reading this, I just know that Joe was like, I don't need an associate for this one. I'm just gonna cook, because it's so fun to write stuff like this. Normally, you have to be all respectful, be like, oh, esteemed, learned opposing counsel, blah 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 blah. You can't be like this jackass. Oh, it looks so fun. Okay. The court may not consider the extraneous materials defendants improperly inject through Dixon's self-serving declaration that is inadmissible on a motion to dismiss. Second, defendant's submission is tainted by the repeated reliance on fabricated citations, a practice for which Blackburn has already been publicly cautioned against, and Blackburn promised to end, but he was a lion. He promised to end to no avail. The court should disregard the Dixon declaration in its entirety. In support of their motion, defendants submit the declaration of Terrence Dixon, which is a solid name, by the way. Terrence Dixon. It's a shame that it's being misused like this. Dated August 11th. The court should disregard it for two reasons. This is technical stuff. I want to get to the fun stuff. Court should disregard it because it's outside the four corners of the complaint. Did I watch the first Alex Jones trial? I did not. I can only imagine. I haven't really watched that many trials, to be honest. I'm mostly interested in, like, personally, I'm mostly interested in, like, motions practice. I really haven't watched that many trials. Even the, I was watching most of the Wolfenbarger trial, but that one went off the rails so fast, I, like, lost interest. But, pretty early on. Okay. This is where we get to the good stuff. The first little part was just like technically correct, legal argument. Now we're gonna get stupid with it. Defendant's motion is replete with misrepresentations and fabrications of legal authority, clearly generated by AI. Courts in the circuit have not hesitated to find that the submission of fabricated legal authority resulting from the use of AI is sanctionable conduct. Lawyers must ensure the submissions to the court are accurate. Here, Blackburn's motion makes countless fabrication and misrepresentations. Damn, this is a lot of bullet points. Okay. Fabricated citation to Krauss. A different court published Krauss in a different year and in a different reporter. That's all of the things. The reporter to which Blackburn cites is instead attributable to People versus Andrade. Neither case stands for the proposition that privilege barred defamation claims based on settlement and litigation-related correspondence between opposing counsel. So it's wrong in every way, essentially. Defendants misrepresent the holding in Barbash, another good name, versus STX Financial. Barbash does not stand for the proposition that Cartagena's claim is barred by New York's 1-year statute of limitations. Nor does it concern limitations issues at all. Defendants misrepresent the holding of Flaherty versus Dixon. I wonder if it pulled Dixon because the defendant's name is Dixon, and so AI searched for incorporated Dixon cases. Flaherty does not state or otherwise emphasize that the judicial system is not a weapon for retaliating against an attorney's legal advocacy, nor does it hold that litigation privilege shields attorney from liability when advocating for their clients' suit. Misrepresent the holdings of Marblestein versus, I'm not going to say that, Anderson versus City of Mount Vernon. Defendants misrepresent the holding of Curiano versus Swazzi. Does not relate to IIED at all. Immuno AG versus Moore. The purportedly quoted language that statements are accompanied by recitation of facts or do not apply the existence of undisclosed facts are constitutionally protected does not appear in either case. Neither case concerns IIED. Case does not concern defamation. Does not relate to IIED. Does not elaborate on emotional distress at all. So these are really bad. Hey, YP. We're being a little silly with Joe Takapina and Tyrone Blackburn. Blackburn thus unquestionably violated his duty to this court to ensure the accuracy and truthfulness of his filings and should be sanctioned. And that's the thing is even when I'm working on a case, I'll look up the other lawyer just to see if they have any discipline. Mostly just because I like being gossipy. But if I look up the person and I see that they've done this in the past, I would look at every case anyway. But I would be looking very carefully at every case to see if there's any hallucinated citations or quotations, just because it would be fun to catch them again. Okay. Notably, several courts had already admonished Blackburn for his ethical violations before he filed the motion. Last year, Judge Cody found that a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Damn, Judge Cody was cooking. Judge Utkin issued a warning to Blackburn because his filings are replete with inaccurate statements of law and full of similar irrelevant insults, misstatements, and exaggerations. You gotta have relevant insults. If you have relevant insults, you're good to go. Most recently, on June 26th, Billy Stickman IV of the United States District Court for the Western District of Pennsylvania, that's another great name, Billy Stickman, ordered Blackburn to show cause why he should not be sanctioned for using wholly fabricated quotations from case law, fabricated quotation from the court's own prior opinion. Oh, this is so bad. Right before I almost stayed at my firm longer because this happened. You look up Love and she has a perfect record. I'm gonna see if I can work on that. Anyway, so there was this first year or second year attorney, and he was suing. I don't know if was he suing or was he? No, he was representing a defendant, and it was my firm was representing a court-appointed like fiduciary, and we were essentially on the same side as a bank that hired another big law firm. As there were these two big law firms, and the guy I was working with was like a senior partner, and I was like a relatively junior associate, but I'm pretty experienced at this stuff. And we were going against this first or second year guy who is a sole practitioner. And in his we'd won on summary judgment. We won the summary judgment, and then there's like an entry of judgment or entry of default or something. I can't remember what it was. But he actually misquoted the judge's order from like 2 weeks before in like a related matter. And it was the same judge, and it was like very clearly not what the judge had said. And so all we had to do, this army of lawyers, just point out the fact that he just misquoted the judge's own order. And it was funny, the hearing that we'd won on, the lawyer from the bank, who was essentially my co-counsel, he did like the first argument, and then I was going to go, and the judge was like, nah, you're good. He didn't even let me speak. He'd already made up his mind. I was like, this is kind of offensive on one hand, but on the other hand, I'll take this. I'll take this W. I posted, I don't know. Yesterday! I tweeted this out as an explanation for how my hearing had gone. I'm Kanye in this video. Oh, I should mute this. Get it off the boat, right? Me saying I'm Kanye out of context. Do not clip that, okay? This is the old pre, Don't clip that. The entire song. He's just back there. That was my vibe that day. I'm probably going to have to get copyright struck there. That's okay, though. Yeah, I'm not talking about anything. I'm so glad that Pusha T isn't from Atlanta. Because every song is a Rico. Every single Pusha T song could be a Rico case. Get 20 seconds? Okay. Okay, all right. So Blackburn misquoted a judge. Judge Billy Stickman viewed Blackburn's actions as very troubling and a clear ethical violation. Oh yeah, that makes sense. Of the highest order, finding that Blackburn invoked a conscious effort to deceive and mislead the court. I should add that I got a claim on my last video from somebody called Young Stoner Life. And I'm deeply offended by that. I played Take It to Trial. Man, and I got a copyright claim from Young Stoner Life. How dare they? I was like, Greta, how dare you? Okay. In his filed response to Judge Billy Stickman's order, Blackburn acknowledged his failure. Do I know who that is? Oh man, I guess I could probably try to get in touch with Brian Steele and see if he could undo the copyright claim for me, but he has no idea who I am. So that'd be kind of confusing. No, I just trimmed out that part. Blackburn acknowledged his failure to verify case citations, claiming he relied on emerging legal technology. I've gotten got for 2 seconds. Like, I'm trying to take it to I'm trying to take it to trial with like YSL people. Come on. Yeah, I know it's not. I know it's not personally Young Thug. It's just probably YouTube's AI or whatever it is. I'm not actually upset. I knew it was going to happen. I was trying to take it to trial. I'm trying. Upsetting. Okay. Blackburn represented that he learned his lesson. Blackburn's such a stating that I now understand that paraphrases, particularly those closely tracking the language from cases, must never be enclosed in quotation marks unless they accurately reflect the precise language. This motherfucker says he didn't understand what quotes are. That was his defense. I now understand that paraphrases, particularly those closely tracking the language from cases, must never be enclosed in quotation marks unless there are quotations. Are you serious? You didn't know what quotation? You don't even know, you're unfamiliar with the concept of a quote? Whew. Okay. He knows what he's doing, Aaron. He's just making up terrible excuses. I found about 15 channels today that have copied my video to theirs and just changed the inhaler voice. Oh, which one? The Fourth Circuit one? I wanted to cover that. It was really interesting, but I knew you were gonna cover it, so I didn't want to like steal your topic. Adamiak, right? U.S. versus Adamiak. It's a really interesting case if you guys aren't familiar with it. Karen, if you want to like link it, the law case. Wait, which one? Yeah. Go from cell chat lingo back to proper English for. He didn't know what quotations are. Blackburn later represented that unequivocal accountability when wrong is how he was raised, in all that he knows. Damn, he's gonna invoke his mama? And that between July 18th, 25 and August 8th, 25, he completed more than 11 hours of CLE courses focused on AI ethics, data protection, and small firm compliance in an effort to ensure this never happens again. Dude, you said that you didn't know what a quotation is. You don't need CLE for that. You need like 4th grade for that. Also, CLE is a fate worse than death. When I was in law school, I went to a tax law conference. That's one of my favorite areas of law. It's way more interesting than it sounds like. And my professor in this session, he was falling asleep like a table behind me. My tax law professor was actually falling asleep during the hearing, and I felt like I was back in class with my professor. That was kind of fun. Blackburn filed the motion after Judge Billy Stickman's admonitions, after acknowledging the impropriety of misquoting cases. Yeah, that one, Cat. And after claiming he took CLE courses on the use of AI. Oh, I actually downloaded a bunch of files from the Adamiak case. Let me pull them up and I'll post them real quick. I haven't read through all of them yet. Or many of them, for that matter. But I'll post a link in case you guys want to see it. Here it is. I got like pretty much all the appellate stuff. Let me see. EDB suggested there are CLEs on like not showing up on jurors' LinkedIn's when, yeah. Yeah, CLE is just like there's this thing too where like you can't just leave it run. So CLE, you can just, it's like a YouTube video and you can just like leave it running. But the one that my firm used, like if you don't have this screen, like or like the window with the video as the one that's on top, not minimized, but not even on top, it'll stop playing. So you literally have to just leave it running on your computer. And you can't leave it overnight because you have to like press a button every 5 minutes so it makes sure that you're not just like leaving it running and not paying attention. And CLE is not useful. Like, I know it's just not useful because you learn by doing, you stay up to date by doing and by reading cases and just doing your job well. It's just not a useful thing in my eyes. Watch me get like a violation for something that I would have learned about on a CLE next time I file something. I probably shouldn't be saying this on camera, but giving somebody trying to get me sanctioned all the ammunition in the world. Oh, totally. Yeah. Ugh. Hold on, let me sub to Kana's channel real quick. Oh, this is in Virginia. It's Richmond. Richmond, Virginia is actually really nice. Oh, maybe not all of it, but I really enjoyed it there. Sorry, I'm looking at somebody else's video while you guys are just watching me look at somebody else's video. But yeah, I'm gonna watch this after the stream. Okay. So Blackburn filed the motion after Judge Billy Stickman's admonitions, after acknowledging the impropriety, and after claiming he took CLE courses on the use of AI. Given Blackburn's history of submitting briefs riddled with it's like he knows me. It's like he knew I was going to be reading this. Maybe he's a fan. Maybe he's watching this right now. This is just... This is A+ work. I'm so happy. More than one. It was riddled with more than one misrepresentation. In his failed attempts to correct his conduct, there is no longer any doubt that Blackburn is just sloppily relying on new technology. Rather, Blackburn's version of, quote, lawyering is simply an unethical ploy to mislead the court and obstruct justice. The court should not tolerate this pattern of deception. It is time once and for all to slap that for Blackburn to be sanctioned for his flagrant disregard of his duties and responsibilities to the court in fabricating and intentionally misconstruing legal authority. At minimum, Blackburn's conduct erodes the credibility. Yeah, the quotations are A+. Blah, blah, blah. Erodes credibility of defense arguments, rendering their motion fundamentally untrustworthy and inappropriate for consideration by the court. Yeah, this is like actual. I don't want to read this stuff. Let's get to the sass. Nah. Hit job statements. This is just the underlying case. Oh man, is this all serious stuff? Because that's less fun. Man, I forgot about the fact that Tyrone, so I can clip it, yeah. Yeah, this is just actual legal arguments. It's less fun. Hey, Karen, did you like try to post it? Did it get blocked or something? I know like I can't post links on like YouTube sometimes. I didn't mean to block it if that was the case. Okay. Only mods can. Oh, that makes sense. I mean, I would make pretty much everybody that's here a mod. I just like... Okay, you're a mod now. I'm just not very good at this stuff. But if anyone like wants to be a mod, you can be one. I'll just give you cast spot. It's extra fun to Blackburn. It really is. There is an AI case here from Judge Gorovich in Los Angeles. If you just like ban everybody right now, I'd be very disappointed, but also kind of like impressed. This was just this judge right here, Stephen Gorovich. I really like him. He's an LA County judge. I had a case in front. Here's one of the later cases I had before I left the firm. It was a receivership case. It was a complex. It was a complex receivership. There was simultaneously a receivership and and something in probate. I can't remember exactly what it was, but he's a really, really bright guy. Really great judge. Very enthusiastic about the law. Sometimes he will crisp exactly. He's very academic. He's very curious about the law, and sometimes he'll have you like discuss things that are just points of interest. But I really like with Judge Gorovich. But this is another AI case. And I was just pulling them while we were watching the video of the Utah case. I sure this isn't too long. 32 pages. Okay, this might be too long. Do you guys want to watch a Brian Steele oral argument? He had an argument like 2 weeks ago or 3 weeks ago before the Georgia Supreme Court. I pulled the briefs if you want to like go through those first. Okay. I'm realizing that 32 pages of just sass is going to be... I'll do this like in a video separately or something. Okay, cool. We begin by noting that nearly all of the quotation in plaintiff's opening brief and many of the quotation in plaintiff's reply brief have been fabricated. That is, as noted above, although most of the cases to which the quotes are attributed exist, the quotes do not. This is bad. Ooh, I won on that statute once. Actually, my very first court appearance involved 437C, and it wasn't even my case. I had never worked on this case, but one of the senior associates was like, "Hey, we're gonna win. I just need you to like go and physically be there." It's like, and he's like, "It's 437C," and I'm like, "Okay." I didn't know what that was. Like, I read it before the thing, and then the other side didn't show up, and the judge was like, "Are you sure it's 437C? I could have sworn it was 437D." And I'm like, I know what 437C says, but I'm not like an expert on this. I don't really know the case very well. I tried to prepare, but I didn't work on the case. I was like, no, it's definitely 437C, Your Honor. And he's like, okay. I was terrified for like a day until I was able to confirm that it was 437C. Okay, let's see here. Let me just pull up the case, the Steele case. I think it is Graham. We can just skim the brief. So it was filed a few months ago, 4 months ago. It's a murder case. I think it's ineffective assistance of counsel. Let's see. He was indicted for felony murder, ag assault, possession of a firearm during the commission of a crime. That is 16-11-106, not 131. He was found guilty of all. New motion. Let's see the enumeration of errors, and then we'll watch oral argument. Appellant's trial counsel rendered deficient performance by failing to request jury instructions on the use of deadly force in defense of property other than habitation, and 2, forcible felony. Interesting. Forcible felony is a term that is it's actually interesting, like what is and is not a forcible felony. Like some are really obvious. Not Instagram. Oh God. I'm not researching Cheryl McCollum. Don't worry about that. Sorry, I started playing a video of Cheryl McCollum on my Instagram page that I looked up because I'm doing a Cheryl McCollum project, aka Mac from the Wolfenbarger case. I realize now that it didn't play on the screen. I didn't need to say all that stuff, and I just kind of snitched on myself, but that's okay. Appellant's trial counsel rendered ineffective assistance by not objecting to the omission of a jury charge on appellant's critical and applicable defense of habitation. Hence, appellant's convictions and sentence must be reversed. Appellant's trial counsel rendered ineffective assistance when the trial court failed to charge the jurors on appellant's specific character trait of truthfulness. Should this court find error in issues 1, 2, and or 3, but find that this is cumulative, that individually any error is insufficient to warrant reversal, then the cumulative error rule must cause appellant's convictions and sentences to be reversed. I wonder if there are bench notes that the judge should issue anyway. Yeah. Okay, let me pull up the Supreme Court of Georgia oral arguments. There's a Don Samuel case. I think my thumbnail is Don Samuel. He did a Supreme Court case in 2023 that involved a rap video, but I can't find the oral. I couldn't find the oral argument for it. 27th? So this was argued on the 27th, August 27th. Mr. Steele. I think it's Graham. Yeah, here we go. I'm making cheese, so can't chat for like 20. You know, in my head, you're like lying, and that's just your excuse for what you're doing. And you just decided to come up with the world's most specific excuse. I'm going to start using that, actually. Making mozzarella. A likely story. Okay, here we go. This is Graham versus the state, August 27th. Wait, who is this guy? That looks familiar. Do I know that guy? That looked... Who is that guy? I swear to God, I've seen that guy before. I don't know. Whatever.
Graham versus the state. Brian Steele for appellant. Michelle Harrison for appellant.
Love her. Love him. Love. Well, she doesn't talk that much. I haven't seen her that many times. Love this guy. Don't recognize this guy. She's great.
Steele, when you're ready.
She is. She dissents often in death penalty cases or murder cases.
Good morning. May it please this honorable court. I am Brian.
Hey, Brian. I'm going to turn that up a little bit.
Steele, and I have the honor of representing appellant.
Oh, we got a little checkered suit going. I like it.
December 18th of 2020, appellant was indicted by the grand jury of Lowndes County for 3 offenses: felony murder, aggravated assault with a predicate offense, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. On the 12th day of January of 2023, appellant was convicted of all 3 charges. There were also lesser included offenses given to the jury, but they convicted of the indicted offenses. That was voluntary manslaughter and involuntary manslaughter doing a lawful act in an unlawful manner. The sentence that appellant is currently serving is life, plus 5 years in prison. That is all at record page 31 through 30.
They do this all the time. There's a case that I'm working on right now where it's the same thing. He got a life sentence plus 5 years for possession of a firearm during the commission of the felony. So you'll see plus 5 years pretty much every time there's a gun homicide. Life, you're eligible for parole after 30 years in Georgia for life with probation. They changed it from 14. It was 14 years until like 2005, I think. You're parole eligible after 14 years, but then that bumped up to 30.
33, 124 through 126. Appellant has...
Every time there's a case, I still look it up to make sure it's 2005 because I'm hoping I misremember it.
Raised 4 enumerations of error. I will follow the court's obviously order at all.
This guy's very like excited about hearing the case.
times and discuss any one that you wish, unless you direct me differently. I was going to start with issue.
The defendant is named Travis Santel Graham. I don't really know anything about the guy.
Number 1, which is defense of property other than habitation, that's found in OCGA section 16-3-24. That code section states that a person is justified in using deadly force to prevent trespass on his or her real property or property other than habitation to prevent a forcible felony. 16136 defines a forcible felony as any felony which involves the use of threat or physical force or violence against another person. In this case, based upon these facts, which are in controversy, there were a lot of people testifying who were there at this fatality, this tragedy, and they have totally different descriptions of what occurred, who was the aggressor, and where this took place, which is all relevant. But based upon this Honorable Court's teachings about slight evidence, I'm going to focus on the evidence that the property was involved and is trespassed in property. I just want to make you aware that there is contrary evidence. Appellant is at his home. His home has a yard. It's a freestanding house. It is July 4th going into July 5th, early morning hours. There is a gathering at appellant's home.
Counselor, why was it unreasonable for defense counsel that testified at the motion for new trial to go with a self-defense theory versus a defensive habitation theory? Why was that not a proper strategy?
Well, there were
Is it an either or? Can you do both?
3 defenses. So self-defense, defense of others, which I'll group as one, and then defense habitation, like you just asked, Honorable Justice LaGrua, and then a third one is defense of property other than habitation. And the reason it was not reasonable to exclude defense of habitation, like you asked about, as well as defense of property, is that those applied, especially defense of property other than habitation, better than self-defense. In self-defense, there are all these guardrails that the courts have put up in the legislatures, that it can't be excessive force.
What's your best case regarding the curtilage or yard of the house being a part of the real property?
Well, Barrett is a good case for that, which is at 292 Georgia, 160, 2012 case. And what I framed it as, the facts show that the deceased and his friends come over uninvited. They try to get into the home. This is actually trying to get into the house. The house is barricaded, the door is barricaded by appellant and his friends. The deceased and his friends retreat into the yard. Some people say the street, but into the yard. Appellant comes outside along with other friends. Appellant warns the deceased and his friends and begs them to leave. There is then verbal and physical confrontation. Appellant is lifted, slammed to the ground on his property, in his yard. There's also statements that this happened on the street. Appellant is then held down and he's beaten by 4 or 5 other of the deceased friends. To me, that is a forcible felony of aggravated assault as well as or false imprisonment.
But counsel, wasn't there a gap in time? Like, didn't that happen and then the assailants went down to the end of the driveway towards the street, it's not clear, and then he went and got the gun and shot later?
I would say it's fluid. It's not later, like we're not talking about, a big transaction occurring over several hours, but yes, it's at the door, the barricade, the deceased and his friends go into the yard, they start throwing things at the house, at appellant's house. Appellant comes outside, tells them to clean up the litter and leave, and stop throwing things at the house. Appellant's picked up, thrown down. Appellant sees someone with a gun in their waistband. Appellant is being beaten by 4 people. Appellant retreats to his car, gets his gun, fires a warning shot. The deceased then comes charging. They call it bull rushing at appellant. Throws appellant's girlfriend out of the way. Appellant fires the fatal shot. That is the sequence. So I'm not so sure I can agree that there's this time lapse like, voluntary manslaughter where there's a cooling off period, but that is how it came out.
But you're saying that the forcible felony was when appellant was being beaten, but it seems like in that scenario, you're going to have to show that the forcible felony was the victim pushing.
Yeah, YP. I think that's generally true. Like the facts of the appellate court is generally going to be about like the law less than the facts of the specific case. Yeah, it's primarily going to be law, less so the how the law was misdone incorrectly or applied incorrectly.
The girlfriend out of the way. I mean, is that even a felony?
I guess it depends on the jury verdict and the purse, but you don't have to have the physical contact to have a forcible felony. It could be a threat. Appellant already knows
But
that
what's the evidence of the threat or because it doesn't even seem like the appellant is claiming that the victim had a gun at that point. He thought the friends had guns. I mean, is that the evidence in the case?
Appellant thought that the deceased had a gun in his waistband and that somebody was going to a car besides appellant to get a gun. That's what he heard. And when somebody throws appellant down, when the deceased throws appellant down, appellant then is being kicked by 4 or 5 other people and beaten on the ground and stomped. Then appellant gets away and gets his gun, and then the deceased comes charging at appellant through appellant's girlfriend. I think that that's a forcible felony in the process. I think that entire dynamic is for a jury to determine. I do not see it as the forcible felony ended, and the deceased and his friends are on the property of appellant, which is why.
Can I ask a question about that? Even if there was a suggestion that there was an interval, under your theory, the previous violent felony, I mean, in other words, even if there was a gap, would at least inform your client's perspective of whether another one was coming?
This is a favorable question. It seems like he is on Steele's side on this one. It's definitely a tough case to make. Ineffective assistance is an extremely hard argument to win. But this question seems like he's open to the idea.
Right, yeah.
I mean, we don't, that's part of the circumstances. That's the totality of circumstances. That goes back to Justice LaGrua's question. That's why I believe that self-defense, based upon these questions, is a harder issue to win in this case. Because jury may find appellant's the only person who pulls out a gun. That's excessive force when you're being thrown down and being kicked and you're able to get up.
Even if we agree with you, counsel, is that really enough? In other words, there's a gap between whether we think this was the best strategy and ineffectiveness, yes?
Yeah, but appellant's trial counsel testified at the motion for new trial, volume 7, page 16.
Oh man, what a flex. He kind of doesn't sound like he's from Georgia. I'm guessing he isn't, but maybe he is. Just knowing the volume and page number off the top of his head, I'm impressed.
That his defense was trespass. The trial counsel asked for a charge on trespass, but you know what charge he got? He got the crime of criminal trespass. That's irrelevant.
What are you doing? Why? Okay. All right. Okay. Yeah, that's what I was thinking too. I thought New York.
Of criminal trespass.
I'm sorry. I need to hear that again.
He got the crime of asked for that his defense was trespass. The trial counsel asked for a charge on trespass, but you know what charge he got? He got the crime of criminal trespass. That's irrelevant. The defense is the defense of property.
No, maybe I misphrased that. It's not what this defense counsel did. The question is could any rational defense attorney have said?
That's the standard for ineffective assistance. If any rational defense attorney, would have done what this attorney did, then it's not an effective assistance. And that's an extremely low bar, and it's kind of speculative. You're guessing, like, could an attorney have thought this? So it's extremely difficult to prevail on that count. A lot of times it has to be, like, objectively wrong. Like if a defense attorney were to let their client plead guilty to, like, 1611-133, which is 15 years, when the crime was actually 1611-131, which is 5 years. Like, no rational person. He's from Queens and went to Fordham. Oh man, they were in our conference. I was a swimmer. I swam at American University for a year, and then I was transferred out somewhere else. But Fordham was in the Patriot League. They were mod me YSL Daddy. Sure, you go. There you go. All right. Yeah. So Fordham. Actually, one of my friends transferred from American to Fordham. Michael DiDonato. He was from Jersey or Long Island. I think he was a Jersey kid. Yeah, I think he went to Michigan Law too. Probably fucking ran from Fordham to Michigan because he's so fucking great, but stupid, sexy Steele.
Self-defense and defense of others is a better choice, even if I disagree with that. So what I'm saying is that I have to be persuaded that no rational attorney, isn't that the standard?
Yeah.
Okay.
It's an objective standard. So I would answer that question, not tell you. I would answer that question that no rational lawyer would exclude 16-3-24. It's just like the Benham case that this court did, and that's under defense and habitation.
Seriously?
It was a tough pill to swallow, that self-defense, because self-defense, you have all these guardrails. But in a defense of habitation, in that case it was a vehicle, you can kill, not you, a person can kill.
Thank you for specifying that the judge isn't killing anybody.
You can kill, not you. A person can kill if their habitation is under attack. You don't need to feel.
Brian Steele was running marathons during the YSL case. He wakes up at like 2:15 in the morning to go run fucking every day and then hit the gym. It's offensive to me.
Like your bodily injury is about to be seriously injured or death. That's the same here. Under defense of property, other than habitation, you don't need to have serious bodily injury or fear of death.
So there are plenty of cases in which choosing between alternate defenses is essentially necessary because there's tension between the defenses. And if you go one route, it essentially forecloses the other route. Is there any tension in this case between the self-defense theory and the defense of habitation theory?
No, and again, I'm actually relying on defense of property,
right,
other than habitation. But I understand the question. They support each other. Even if the jury does not find self-defense or defense of others, they still find defense of property under the habitation. That's the beauty of this. And it was not strategy, because the defense lawyer, and he's a great lawyer, he's been practicing, at that time, he's been practicing, I think, 55 years. But his defense said it was defense of property. That's this defense. He also asked for a charge on defense of habitation.
Didn't he specifically say, I don't really see it as a defense of habitation case? I see it, and this is a quote, I see it as a defense of himself and his lady.
Keep reading. It should say, and trespassed. It's in there. It should be page 16, volume 7. If I'm wrong, then it's right around there. But that's what he said. I see this as a defense of trespass and self-defense, but not habitation. Yet he asked for a charge on habitation that the judge said he would give, but it never came. This case is broken. And this jury instruction is broken. And these are the facts. These are great facts for a charge on defense of property other than habitation. And that's how I view this, that issue in this case.
That was a good way to kind of tie it all together. It's a broken. Yeah, he did.
On the,
And again, that's kind of stuff builds credibility with the jury. When you know the record that well, they're going to be inclined to believe you.
second,
It doesn't mean you're going to win, but it goes a long way.
and I see the bull rushing, by the way, and the slamming down and being charged that may not be self-defense where you shoot someone. That's excessive. But when it happens in his yard, appellant's yard, under this statute, appellant had every right. That's a forcible felony. That was a threat of a forcible felony about to happen. He had every right to shoot and kill.
Yeah, that's the funny thing is the YSL jury said he spoke too much, and then when they asked why they acquitted, they just like basically quoted everything they said.
The second issue I find fascinating. So when is it that you're no longer doing habitation? You know, I read all this honorable court's cases, and I understand that if a person's not entering the habitation, this court has said it's outside, then habitation, which is 16.323, does not apply, defense of habitation. But here we have the deceased and his friends forcing their way into appellant's home. Appellant and his friends had to barricade the home. The deceased backs away. Is it really over then? The deceased and his friends are now throwing things at the house.
Where exactly is it that they're actually attempting to get into the house? Not threatening to get into the house, but actually attempting to get into the house?
That should be at page, volume 5, 338 through 339. They were told to leave appellant's house, property. They were refused admission into appellant's home. Appellant's front door had to be barricaded from the deceased, and that's also volume 5, 420 through 421. The deceased and his friends then went outside and started to throw things at the house and trash at the house, and that's when appellant came outside to leave. Then,
so it seems like there's no dispute that there was the slight evidence that would justify the instruction. It's just that the instruction wasn't given and then counsel didn't object, right?
perfect. That's perfect. And counsel, I don't know. He said at the motion for new trial that was his defense. And I don't know where the criminal trespass charge comes from, but it's right in between the self-defense charge. But it's charging on a crime. It's not charging on the statute as a affirmative defense.
That's a problem.
So I got very confused how that all happened. So under the 16-13-23 defense of habitation, I believe that the curtilage now is part of the house. Why would anyone believe that the deceased and his friends who were denied entry into the home, who said they're coming in, who were told to go away, they said we're not leaving, we're coming in. Why would anyone believe that you have to wait in my home? I can't come outside and shoot them. They are still trying to get into the home. That was my point, that the curtilage, this is a continuing
But the
process.
curtilage question is more of a novel aspect, right? And for IAC, that's pretty tough.
Everything's tough, but I have a problem because there's another code section.
They respect him so much. A lot of they're looking at him as an equal, not as somebody that's being annoying and doesn't know what they're doing. They're like genuinely asking him questions and they respect him as an expert. It's really nice to see.
Back to back that says defense of property other than habitation. So I want to make clear that may answer the question, that habitation does not include curtilage. So I want to be clear that I understand.
Do we, in our defensive habitation cases, when we talk about defending the home, have we ever, I mean, is it possible that curtilage has been involved and we just haven't parsed it out?
I think so. It's Jackson is the case, and that might be a better answer. Justice, I apologize when you asked that question. Jackson may be a better, it's 318 Georgia, 393, 2024. There was an attempt to enter the habitation, and there was a threat to enter the habitation, so there were people on the curtilage. I'm not saying it's perfect, but it seems like it's outside, and defense of habitation was at least discussed. And I think it's a good issue here because if somebody comes to my home, tries to force their way in, I am not letting them in. My children, I am not letting my wife is there. They go outside, I still am of the belief they're coming in the home. Unless they made it clear, it's a wrong house, we're not coming in. And they're coming at me and throwing things at my house and slamming me to the ground. I believe that as a citizen of Georgia, I would understand that I have a right to kill them for defense of my habitation, even though I understand that the two statutes are there.
Well, after the warning shot, however, they scattered after the first shot.
Yeah. I mean, Justice LaGrue, a jury may find that none of this happened in the yard. The
And
prosecutors...
there's evidence that would support that finding.
But there's evidence to support... Yes.
I didn't say there wasn't, but there's evidence to support the finding that it didn't happen in the yard.
Yeah, the prosecutor said that. Prosecutor said very eloquently in her closing, this is like a trial of two different people.
The statute contemplates that, right? Because it contemplates the prevention or termination of a trespass.
Absolutely.
In other words, prevention would always be you are not in the act of, you are trying to trespass, you're not on the property.
Exactly, or attempt. They use the word attempt as well. That's exactly right. That's why I think that habitation is in play too, because under these facts, these specific facts, I think defense of habitation was in play. And that charge was requested. The trial judge said, I'm giving that charge, and then it vanishes.
Yeah, that's
the prosecutor even commented in her closing argument that you will hear defense of habitation. But I was being true to the record. The trial lawyer said, I did not want defense habitation, but he did say, and Justice LaGrue, I hope it's on that page, he did say, I promise you, he said, it was a trespass case.
So the same trial counsel who requested the instruction later says he didn't want it.
Yes, he explained, and this happens, I did my jury charges early, so during the trial I changed my mind. I can understand that, but he definitely said, I want the trespass. It was never given. And the charge that was given, I've said it 4 times, I apologize. I know this court is very bright, you don't need me to repeat, but it was phenomenally wrong and in
Somebody needs to clip that, because you could get so much use out of that. It was phenomenally wrong. I need to hear that again. I love Brian Steele.
To repeat, but it was phenomenally wrong and inapplicable to give a crime charge on what is criminal trespass.
Yeah, YP asks, I can't believe Laurent's appeal was denied, or they're not able to get the transcript of the girl who testified against him. I think the problem with that would be you can't like redo the facts in an appeal. It has to be like an error in the law. Yeah. No, I know what you meant. I know what you meant. But like what the facts are for the trial court to determine, and then it's not fair, but it is what it is.
The charge that he wanted was 16-3-23. I mean, I feel very favorable about this case because of the facts, but more importantly, the law. If you don't have any other questions, if I could reserve, I would like to do that.
Thank you, Mr. Steele.
No, thank you for everything you all do.
Ms. Harrison?
Silly, yeah.
Good morning, Chief Justice Peterson, Justices. May it please the court. My name is Michelle Harrison, and I have the privilege of representing the state of Georgia in this case. Much like Mr. Steele, I will kind of follow the same procedure and address any questions as you have it as we go. Again, Mr. Steele raises ineffective assistance of counsel. Multiple claims of ineffective assistance of counsel, but they all revolve around jury instructions. And as this court has held, it must be so patently unreasonable that no other competent attorney would have taken or made the same decision. That's just not what we have here. Starting with defense of property other than habitation. Mr. Steele indicates that this is an easier jury instruction for a defense justification than self-defense. I see it the opposite way. Defense of property other than habitation has 2 essential requirements. There must be property, real property involved. And there must, in order to allow deadly force to be used, there must be a forcible felony. Both of those are very much in question in this case. You have questions about whether this occurred in the property. Several witnesses testified that they were never in the yard at all. There were also several witnesses who testified that they were. So the evidence is conflicting. Were they in the yard? Were they not in the yard? There's also other evidence that indicates that when the shots were fired, they may not have been in the yard at all. The shell casings are found in the roadway.
So, counsel, the state's position is that this code section, 16.324, does not apply to actions unless they are actually on the property being defended?
They do have to be defending the property. There's testimony that they were never in the yard at all, that they were never intending to go.
But there's testimony that there were.
There is. That is correct.
I mean, that's the critical point for determining whether they get the charge. Was there evidence that the jury could have found?
Correct. And I do believe the charge could have been given. I just don't think it was unreasonable for Mr. Bright.
This is, I mean, she has the advantage, and she's very much leaning to the advantage that IIC is a very difficult thing to show. But she's kind of already ceding a lot of ground here. It's like, oh, it was wrong, but it wasn't super wrong, is basically where she's starting off. Yeah, this is
not
tough.
Requested because of the questionable evidence and the conflicting evidence. The evidence that there was that Mr. Franklin, the decedent, did go into the yard, he and his friends, but there's also the testimony that they did not, that they never entered the yard.
She's just repeating what she said that gave rise to the question. She's repeating herself instead of answering the question.
Was there conflicting testimony about after the first shot? There was testimony that people left, yes? Or scattered,
Correct.
sort of.
Correct. Yes, sir.
Was there any conflict in the testimony about that some, including the decedent, after having scattered, came back?
Into the yard or?
Came back to the property, whether they came on the property or not. They went away from the real property and they came back toward it, whether they went on it or not.
Correct. I do believe that when there were scattering, some people did go down the road. I believe the testimony was a couple of houses and then maybe came back to the area because that's where their vehicles were parked, were in front of Mr. Graham's residence and other residences on that street. There were multiple vehicles. So I do believe when they scattered, they did indeed come back to the area. But at the time, at the time that this evidence is coming out at trial, the testimony from both state witnesses, defense witnesses, I believe Mr. Bright is having to consider, what is the jury going to believe? What is the jury going to buy? Which party do they believe?
This is dog shit. She's probably going to win, which is what upsets me, but this is terrible.
As to what happened. Do they believe this happened, that he was actually defending?
I don't think she's not really making a good case that this was a reasonable strategy. Just kind of saying the evidence was in conflict. And if the evidence is in conflict, that militates in favor of an acquittal, not a conviction. Which means you do want the instruction. Because you only need to raise, reasonable doubt.
The property, because if he doesn't, then they're not going to do this.
This does feel phenomenally wrong.
But
again, she's probably going to win because that's how this works. But
other question is,
have I been listening to Young Boy recently?
Do they believe this is an aggravated assault to be the forcible felony that's required for defensive property? I
haven't been listening to a lot of Young Boy recently, unless there's a different YB.
Than habitation.
YG, absolutely.
No doubt there was a fight. That is undisputed, I believe. Everybody agrees there was a fight. The fight occurred in the roadway. When the fight ended, that's when Mr. Graham went to his vehicle and retrieved the gun. And shortly after is when the shots were fired. Mr. Graham
I got this for $5 at Goodwill. It's one of my favorite shirts. It actually has like the basketball player's number inside. So it's a guy named Jazz Williams, I think. But it was a great buy.
Testified himself that he fired because Mr. Franklin, the victim, was coming at him. Okay, that could be simple assault or it could be aggravated assault. There was testimony of a fight, but it was just that it was a fight. There was no testimony that there was any type of serious bodily injury as a result of the fight. As a matter of fact, I think the only injury was a cut to Mr. Graham's hand. There was no bruising, no bloodiness, no...
Did she just say, hold on, I need to hear that again. Did she say...
Fight, but it was just that it was a fight. There was no testimony that there was any type of serious bodily injury as a result of the fight. As a matter of fact, I think the only injury was a cut to Mr. Graham's...
The only injury was a cut.
...hand. There was no bruising, no bloodiness.
There was no bloodiness. There was just a cut on his hand.
No medical attention required. This could have been
It was one of those bloodless cuts.
Fight, just a fight. Regular.
Getting stomped out by 5 dudes.
Hit, punch, kick, slam. There's no evidence.
That sounds bad. What?
To fight. Regular. Hit, punch, kick, slam.
That sounds... Okay.
There's no evidence that this would have been serious bodily...
You just said kick, punch, hit, slam, or whatever it was. What do you mean there's no
injury to arise to the...
They had their Timbs on.
...level of an aggravated assault as opposed to simple assault, which just requires apprehension of a violent injury, which...
This doesn't seem like it's helping very, very much. Because again, you're just looking for acquittal. You're just looking for reasonable doubt, and she's kind of sounding like they should have given that instruction.
Would be a cut to the hand.
Well, but the fact that the serious bodily injury didn't happen necessarily doesn't mean that it wasn't aggravated assault. It means it wasn't aggravated battery.
Correct. Well,
I don't know if she believes this. I mean, this is much worse than I thought it was going to be honest. Based on Brian's argument, I'm like, yeah, it sounds like the lawyer absolutely messed up, and it should be ineffective assistance, but I don't think he's going to get there. But she's making this is like Brian, speaking through her. She's saying the things that he wants her to say.
Aggravated assault 16-521 requires at least fear of serious...
He was just getting stomped the fuck out. What are you talking about?
Right. So the fact that it didn't happen,
correct,
that it didn't rise to that level, doesn't tell us whether there was reason to fear that it would, right?
Correct. But I think that's a consideration that Mr. Bright has to take in as he's determining which jury instructions to request. The jury very well may not see this as being something that would...
Yeah, but they very well may.
...would rise to the level of aggravated assault, and if it doesn't rise to the level of...
Would he have been okay not to ask for defense of self or others?
No, I think if he had not asked for defense of self or others, then this probably would be a different situation.
What does a person have to reasonably believe to use deadly force in the self-defense of self or others?
It would be the same thing, and I believe the self-defense statute also includes forcible felony at the end of it. But in this case, if the jury instruction given by the court doesn't include that forcible felony language at the very end of it when they're giving the...
I guess what I'm getting at is you would essentially have to persuade to win on a defense of self or others.
Man, this is not going the way I thought it was going to go. I'll be honest.
Yes, sir.
That's deadly force. You're going to have to convince the jury that you feared the same thing.
Yes, sir.
As defensive habitation, defensive property other than habitation, yes?
Yes, sir.
So why would you have to do any calculus about will they believe it? Because either they're going to believe it. Now, it may be that your argument is they're going to believe it on defense of self or others because this was a group of people, and therefore it's sort of harmless because you really were asking the jury the same thing either way. But if they're either going to believe it or not, you can't say, well, it's a reason not to give the jury charge if I have to convince them of the exact same thing, and there's another conceivable way to win.
Yeah.
Correct. And
yeah, if you can win because of reason A or reason B, and you only request reason A, then requesting reason A isn't a reason to not request B. I thought there was no chance he was going to win this, but maybe, I don't know.
I believe that self-defense or defense of others is actually a more clear more concise jury instruction in this situation, because you do have to consider the same thing. But it takes out the other element being required, the yard, whether or not they were in the yard at all. So,
But again, you keep saying whether they were in the yard, but the code section talks about preventing.
This is not going well. Again, she's probably going to win because nothing's ever ineffective assistance of counsel, but this is not going well.
correct.
Right, not just terminating. So if someone is taking aggressive action toward my property, I don't actually have to wait for them to be on the property to claim the protections of the code section, do I?
No, sir, I think the statute does indeed say prevent or terminate. But again, that's also language that could be confusing to a jury.
How?
When we're considering self-defense and defense of others, you're still considering whether it was aggravated, essentially aggravated.
This is a really bad argument. The jury might be confused by prevent or terminate. I mean, come on.
Assault, the great bodily injury, fear of death, to be able to use the deadly force in return. So I don't believe it was unreasonable for Mr. Bright, the trial attorney, to choose not to request this, because it is a little more arduous, and it is a little more confusing, whereas self-defense and defense
It's a little more arduous? That's not a good reason.
of others is a little more simple when defining what they must meet in
A little more simple. It's a murder case.
order to grant or deny self-defense as a jury instruction. I also think that there's no prejudice in this case because of that, because they did consider all of these things when they were considered. They considered the amount of force from Mr. Franklin.
Okay, so they considered all the stuff, but it was too complicated for them to consider it. I got it.
To Mr. Graham. They considered that when they were considering self-defense and defense of others.
This makes no sense.
So,
oh man, Brian Steele reserved his time, so he's going to get to respond to this too.
there's nothing to show that the outcome would have been different had this been given. It was still the same requirement, the same amount of force that had to be exerted to be defended against. So our situation, I believe it's not unreasonable because you don't have the deficient performance. It wasn't unreasonable for him to choose not to address that.
I need to hear that sentence again. Because did she just say it backwards? She said because it wasn't deficient perform. Did she say that? What I think she just said?
To be defended against. So our situation, I believe it's not unreasonable because you don't have the deficient performance.
It's not unreasonable because you don't have deficient performance. It is because it'd be like that.
It wasn't unreasonable for him to choose not to.
Because it wasn't deficient performance, it wasn't deficient performance? She's not wrong. I mean, I guess that follows logically.
Address that.
What?
Just like it was not unreasonable for him not to choose to address or request defense of habitation. Because after the habitation, or after they questionably approached the house.
Stop it. Stop.
That had ended. They had.
It's not you. You're a
there
good
was
boy.
testimony that they had reverted back to the yard, back to the road. So there was.
But that you said they came back though.
Was no dwelling involved at that point.
This is not going.
And our position would be that the curtilage, because 16.3.24.1 is so clear in its definition of what a habitation is, that the curtilage is not part of the habitation. And because there are both defensive habitation and defensive property other than habitation, that it's very clear that there was an intention for those to be treated differently. So it was not unreasonable for Mr. Wright not to choose to.
Wait a minute. Did they say Mr. Wright? Is this what I think it? This better not be what I think it is. It's not Mr. Wright, right? No.
Take defensive habitation because he had self-defense, but
Bright.
also because any issue
Please?
involving the dwelling had ceased at the point that the shots had been
Well,
fired.
wasn't there some evidence that the other
I don't
group
care
was
what you guys
coming
say.
back towards the yard after the first warning shot?
Yes, ma'am. There was evidence that they were coming back toward the yard.
So there's slight
toward the
evidence
area.
at least.
Correct. But not to the home, to the actual dwelling.
Well,
Oh, that's not a good. She's usually she's been pro prosecution the last few cases I've looked at, so that's not a good reaction. Mr. Wright was Moon Tung's first lawyer at the trial court and the revocation hearing. I don't think it's. I don't think that's. I think they said Bright. I think it still said Bright. I think she just misspoke.
some evidence that the other group was coming back towards the yard after the first warning shot?
Yes, ma'am. There was evidence that they were coming back toward the yard.
So there's slight
toward the
evidence
area.
at least.
Correct.
Actually, what case was that? The last time we looked at. Oh, it was Andrew's case, Andrew Fleischman's case, the identification issue with the homicide involving the expensive watches. She and I believe Peterson dissented on the grounds of harmless error.
But not to the home, to the actual dwelling.
Well,
No, I'm sorry. We're watching this again. That was too perfect. That was. Oh God. Oh
some
boy.
evidence that the other group was coming back towards the yard after
I
the
know,
first
right?
warning shot.
Yes, ma'am. There was evidence that they were coming back toward the yard.
So there's slight
toward the
evidence
area.
at least.
Correct. But not to the home, to the actual
How do you know where they were going?
dwelling.
Well,
I'm sorry. I can't stop. Okay, one more time.
Dwelling.
well,
Like, in my position is that.
I'm sorry. One more time. I mean it this time.
In
I mean
my
it this
position is that.
time. I mean it this time.
Well-
This is really the last time. Okay.
Dwelling.
Last time.
Well-
Like, in my position is that defensive habitation
Oh my God. She's probably still going to win, which is the worst part.
Habitation is specifically defined as being the dwelling.
Well, where's the line?
They were coming back towards it, though. That's the whole thing. That's the whole point. You don't know where they were going.
Have we ever said that it is that limited in a case?
I do not believe that has been ever specifically said by this court.
This is incredible. This is going really badly.
Like if you're standing on your doorstep of your home, is that not your habitation?
I don't think that's ever been truly defined by this.
What would the state's
Well, fortunately, this is the Supreme Court, so they can do that.
position be?
Truly defined by this.
What would the state's position be?
I think it would honestly be a case-by-case basis.
That's not. She didn't ask you a case by case. She asked you in this specific scenario, if you're on the doorstep, what would it be?
I think it would honestly be a case-by-case basis because it depends on what is your doorstep. Is it your front porch? Is it the step on the ground? Is it the step off?
Stop.
Is it in your yard?
Is attempt also included here?
I'm sorry.
Does the statute also include attempt?
It does.
Okay, so if I know that a group of people have previously attempted to enter my home, and then they ran away briefly, and now they're coming back, why doesn't the fact that they're coming back, why am I not reasonably entitled to assess that coming back in the light of the fact that those same people just tried to break in?
Okay. I think in this case, the evidence was a little more questionable. They went to the home for a party.
I recognize there's
right.
Disagreement on the evidence.
Right.
Just answer the
Okay.
question the way I asked it.
Yes, sir. I think it would depend on what you are seeing. I think you can assess it. I do think that is something that you're going to assess because you can prevent the attempt of the person coming back into your house.
Well, I guess, the nub of the question is when can you use that force? And if people are in your yard with a battering ram and guns, and you know that they're going to try to beat your door down and then shoot you, do you have to wait for them to beat the door down before you can use force to defend your home and everything inside it, including your family?
In that situation, I would say if someone is in your yard and they are coming toward your house with a battering ram and a gun, I do think that is a little more reasonable to say they're coming in my house.
What if they're just running at your front door?
Sir?
What if they're just running at your front door? No ram, but you also know they've previously tried to break in, and now they're running at your front door again.
That is a very, that is a very
How close do I
good
have
question.
to let them come before I can shoot them?
Hold on, I want to show you guys a live action reproduction of the case. This is actually a live look in at the prosecutor right here. Oh man, this joke is getting ruined by the fact that I can't find this link that I'm looking for. Come on! No! Not you. I'm just gonna give up on this joke. It was a good joke, too.
I'm in danger.
Oh man, I ruined that.
There. I'm in danger.
I completely blew that joke. That was so stupid. Why'd I even bother doing that?
Why are we fixating on entry into the home? The code section talks about an attack upon the habitation. You can accomplish that from outside the home, right?
Correct.
So, like, for example, throwing things at a house
Correct.
is an attack upon the house, yes?
If it is attacking the dwelling,
It's
yes.
evidence of an attack on the house, yeah.
If it is, yes. If it is approaching the dwelling, again, in this case.
I understand it may be a contested, whether, but if I am outside of a home with heavy, hard things, throwing them at the home, I am.
Sounds like a good time.
Attacking the home.
Correct.
And if I have done that, and I leave, and I come back, do I have to start throwing again to be conclusively perceived as attacking the home, or
Man, lawyers, we're a bunch of nerds, aren't we? I'm realizing that watching this.
am I a threat to attack the home? Again, question of fact, I'm not saying conclusively.
Correct.
Is that not something that a reasonable occupant of the dwelling could say, hey, they're coming back and they're going to do this again?
I definitely believe that could be a reasonable fear, absolutely. Again, I don't know that was what occurred in this case. I think part of the testimony or the evidence shows that these people arrived at this house in vehicles that were parked in front of the residence. It is reasonable to believe that they're going to come back toward the residence to get to their vehicles. So,
Well, and those are all things the jury can assess. And to your earlier point, there's conflicting evidence since the jury gets to make those decisions. But what we're trying to figure out is what is the effect of trial counsel having not secured that instruction, and would that have made a difference under these circumstances?
again, I don't believe it would have made a difference because he does have the ability to defend himself and defend others that were at his residence.
Yeah, but then you have to prove that you weren't the initial aggressor. You have all the other sorts of things that come with defense of self and others, whereas this just means if I had a belief that they were attacking the dwelling or if they were attacking, coming on for criminal trespass, and I think that someone was about to commit a violent felony, whether or not I started it or not, I don't have to deal with that.
That is
Right?
true. Yes, sir.
There are some incredible reactions in this. I'm so glad we watched this.
That is
Right?
true. Yes, sir. We would say that this was not so patently unreasonable that no other attorney would do it. We would also say that there's not prejudice in this case. As a result, if there are no further questions, I would cede the remainder of my time.
Thank you, Ms. Harrison.
Thank you.
Mr. Steele, I believe you have just under a minute.
He's going to cook for under a minute? Let's see this.
So just to be clear, it is volume 7, Justice LaGrua's question, but it's at page 16. Justice LaGrua was reading from page 11. And this is trial counsel. A part of our case, he's defending himself against trespassers on his property. And the court charged on trespass. He charged on the right of self-defense. He also charged on stand your ground, not to retreat. The trial lawyer wanted this charge. He did not get it.
Man, that's I really think that might be what sways the court. The fact that it was request but just not granted or forgotten, I guess.
He did not ask for it, but he argued it. In addition, it's exactly what I just heard, in my opinion, when I was listening intently. You don't need a serious violent felony for 16.323 to apply. All you need is a forcible felony. It doesn't say a violent felony. It says a forcible felony. Holding down on the ground, appellant was already the victim of a forcible felony. He knows what's going on here when the person is rushing at him. He has a right to shoot. They're on his yard.
You can finish your sentence.
They're on his yard and they're attempting to commit a forcible felony. That's all that has to be done. He can kill.
Thank you, counsel, for both sides. Well argued. We'll get you an opinion.
It's incredible how much he packed into that less than a minute.
Within the time required by the Constitution.
Chief Justice.
God, it's just so good. All right, I got some writing to do. I could do some work. I think I'm going to call it a night. He didn't say God for. You're right. That might not even be Brian Steele. It could be somebody in a Brian Steele suit. You're just going to leave us on a cliffhanger? I mean, I don't know what's going to happen. I don't have the answer to what happened. It's never an effective assistance, of course, so we'll see. But this is a pretty strong argument from Steele. Oh, we don't know. This was just argued on the 27th. So just a few weeks ago. We'll probably have to wait a couple months to find out what the answer or what the outcome is. Oh yeah, there's the fight tonight, right? What's that, a couple hours out? Yeah, that was not a great argument from the state. Yeah. It's rare for any date on ours yet? No, not yet. The state needs to respond to our motion. I think we filed on the 2nd. So the 22nd, I think, would be the state's deadline to respond. And then we get 20 days, which would be 14 October, I think 6th. I'm counting the days kind of quickly. But I think we would have our reply due on October 6th. And then it is slated for the December term of court, but we're not doing oral argument, I don't believe. No, we're definitely not doing oral argument. I don't think there's any need to. And yeah. So hopefully it is decided relatively soon, but it'll be a while. Yeah, he's over a year in prison next month, so that's tough. But hopefully things work out. I'm glad that we got to tell Mootung's side of the story at the very least, even if nothing else. And I have a lot more to tell once it's time. There's still a lot more left to tell. I mean, the injustice in his case goes back to at least 2003. I think his first conviction wasn't even a crime, which is kind of crazy, but we'll see. I am looking forward to getting to tell the whole story at some point, assuming Antonio's interested in that. Obviously, if he doesn't, I'll keep confidential. They're not talking about the case if he'd rather not, but he has a wild story to tell, and I hope he gets to tell it, or chooses to tell it, and share it, because, I don't know, I think it's important to tell. But yeah, I'm gonna call it a night. I gotta do some more writing on a different case. I was kind of on a roll earlier, so I want to get back to it. But yeah, I'll talk to you guys soon. I might do a video tomorrow. Yeah, I hope to get another, at least one or two more people in the YSL case. There are another couple cases I'm interested in. I really like Demise McMullen's case, but it's probably too late to do anything on that one. That case is crazy, but we'll see. But okay, everybody, thanks for watching, and I'll try to find some more stuff. I didn't get to the Don Samuels thing, and I made that awesome thumbnail just for that. But we'll see. That's a really interesting case. I might do like a lyrics stream on lyrics and stuff. Do that. Do the Don Samuels case. There's a New Jersey case. Maybe some YSL lyrics. But it's crazy. But okay, yeah. Thanks everybody. I'll see you soon.